All right, everyone, I'm going to call the docket. This should be short. There are only like two people here. Gustavo Jimenez, Ryan Westbrook, he's in.
Yeah, I have updates for you on the settings in federal court.
All right, after I call the docket, if you'll give me those updates. Angie Ford, custody. Jesus Suarez Marino. Jesus Suarez Marino. Thank you. Austin Rodriguez, custody. Carl Robinson, custody. Charles Atwell, Edward Castillo. Jose Mejia. Napoleon Velasquez, custody. Jonathan Alfaro, he's in custody, correct? Oh, State Hospital, okay. Jonathan Alfaro, we'll take that up quickly then. Stevie Stokes, custody. Linda Flores, custody. Julian Renee Suarez. All right, the attorneys, you guys have been here before, so you know the rules. And Jason Wolf, let me just sign into Odyssey, then I'll take your matter up. All right, thank you. All right, Mr. Wolf on Westbrook, what are the dates?
Judge, the final pretrial is March 24th. Jury trial is March 30th. Let's see if they actually mean it this time.
Okay, let me see. I'm going to give you a date, and if you find out something before this date, just let me know and we'll set it on a different date.
Okay, Judge.
Okay. Let's try Norma.
Yes, ma'am.
Are we good for April 30th?
Yes, ma'am.
All right, so we'll put it on April 30th. And if you know that that March 30th didn't go, just come in and let us know so we can reset it. Then you won't have to come in.
Awesome.
All righty. Is there anything else?
No, Judge.
All right, thank you.
Thank you very much. Y'all have a good day.
All right, you too. Norma, that's on Ryan Westbrook.
Yes, sir.
Yeah. Judge, can I introduce you to?
Sure.
I have a. Okay.
Hello.
Hi.
Hi. So what's your name?
Andre, I'm Andre. This is Alex. Nice to meet you, Your Honor.
Andre.
Alex.
Jessica.
Young entrepreneurs, two gentlemen that do their own podcast. They're striving to make the world better, and they've reached out to me. And then Jessica is a law student. She's actually going to get her doctorate here soon. So I just wanted to show them the courthouse and introduce them to you.
Awesome.
Yeah.
Well, nice meeting you guys. And Jessica, if you have free time, we're having a jury trial today. So when I was in school, I would love to see things happen instead of just people talking about it. So if you want to sit in here for a jury trial, you can sit there. We're going to do voir dire probably at about 10:30 whenever the jury comes up. And then in the afternoon, they're going to have testimony. So you're more than welcome to come in if you're free.
Great.
Yes.
Thanks very much.
And I'm still going to pay you if you come in.
Oh, just there's no pay going on here.
Okay.
Thanks.
All right, thanks. You guys have a good one. Nice meeting you guys.
Mr. Alfaro.
Mhm. Yes.
Extended.
Okay.
So, did you get the date?
No.
November 26th.
All righty. All right, so Norma, give me a date for him, January.
January of 2027.
Yes.
We're up front of the tables after the jury box at the right.
It's usually what ends up happening when they get re-extended. Sometimes there's no, the doctor finds that they're not going to be competent for the foreseeable future.
We do mid-January and January.
Let's do mid-January.
No, I'm sorry, the 14th or the 21st.
Let's do the 21st. All right, State Alfaro is being reset for January 21st. You're welcome.
One of the elevators, I got stuck in the elevator and I closed it. The one here at the far end.
Really?
So it finally opened and it stayed open. It's just like, wait, like this.
Oh, no.
So, yeah. And there's like 6 of us in there.
No.
Is it the one that always shakes?
Yes.
Yeah.
I knew that one was gonna do it.
Oh, yeah.
I was in.
I'm sorry. I'm always
And
afraid.
it finally went down.
Mm-hmm.
And the doors are going like this.
Yeah.
I was like, no, no, everybody get out.
Oh, no.
It was awesome. I didn't know something like.
How do you know me? You just never been in there. Okay. That's bad.
I think there's like an emergency.
I thought there is. I thought, yeah.
Thank God. It's already gone.
All right, Vashawn,
I didn't know.
happy Black History Month. So, hey,
I didn't realize Swayze's already 6 months old.
oh, my baby, he's so cute. All right, Vashawn, I'm going to do a guy that I always talk about, Carter Woodson.
Carter Woodson.
Yes.
Carter Woodson.
Also, Vashawn, I could talk about Angie from All My Children.
You could.
You know, All My Children with Angie, that was the first Black power couple on soap operas. And do you know they brought them back for a while before All My Children was removed from television? And they still look the same. Angie does not age, does she?
So,
Right, Norma?
Yeah, she still looks good.
she does still look good.
Oh, still looks the same. All right, we have 2 people in the waiting room. Andrea Matos.
That's the hearing judge for the early term. I think she filed a motion for early term.
Yes, can you all pass that paperwork to me?
Which one? William Juarez. And I think the judge, and I don't think the attorney is here
Okay.
because he's trying the case with with Megan. That tall guy. She had told me it was that tall guy. Andrea. She's the defense attorney. The prosecutor is the.
Right.
John?
Jeffrey Wright.
Jeffrey Wright, something with a J.
And Attorney Matos, just give me one moment. I'm putting something in the system right now.
Okay, thank you, Judge.
Megan, happy Black History Month. Oh, we did Carter Woodson. And we also honorable mention Angie from All My Children.
The Carter Woodson I'm reading was the father of Black history.
Mhm.
Negro History Week in 1926, which actually evolved into Black History Month.
Yes. And you know why they chose the date that they chose? February being Black History Month.
Why?
Oh, you guys, see, I'm supposed to ask questions like I know the answer. But you know what? It was always amazing when I was in college. there was always what I call the Black question. And it has something to do with Black history. Okay, imagine you're in school and I was the only Black person in my class. And the teacher asked the question, then everybody looks at me. Like I'm the keeper of all Black history. And so thank goodness for my history teacher and for my mom and grandmother. I said, well, I know the answer, but everybody should know this because history is history. And then I would tell them, I'm like, stop looking at me. Oh, so it's not from 8:30 to 1.
And she says anytime between 8:30
Oh, well, let me do the 8:30.
and 8:30.
Should I do 8:30? Am I gonna do 8:30?
How close is it to your house?
I have no idea. You know what? Oh, have her put me at. Let me look at my calendar.
Okay.
Get up to the babies at 8. You know what? No, I'm gonna do 8:30.
8:30?
I will get up for the babies at 8:30 to read to them.
I'll put it down. I'll let her know.
Oh, and it's from 8:30 to when?
To 1 o'clock.
No, but I mean, am I reading from 8:30 to 1?
No, I think it's any time, you just pick a slot, like what time you want to be
So
there.
can you tell me what the slots are?
She didn't tell me, she just said those are the. It's from
All right,
8:30
if you
to-
can find out, is it like 8:30 to 9 or?
Okay, sure.
Yes.
Get in the gate, and stuff like that.
Morning, Judge.
Morning.
Your Honor.
This is on Gustavo Jimenez.
Let me find him.
Should
Should
be
be a
the
recall from
top of the
yesterday.
dock.
Okay. Odyssey is moving very slow.
I think that whoever named it, like they obviously didn't read Homer's epic of like the Odyssey was not a fun time.
Oh,
So
Yeah.
okay. So now I remember this case. So what are we doing? Do you-
Judge, we're gonna be filing a motion to appoint a state expert.
Okay,
I've shown this real quick to Renee. We're good
Yep.
with it. Then we're gonna recommend Dr. Brian Scott, SKOP.
SKOP.
Yes, ma'am.
Okay.
Yeah.
And have you all talked to Dr. Scott?
We have not.
This-
But he works a lot with the magistrate court.
Um,
regarding, does the court want to set this for status and put, like a little bit
Yes.
ways down so we can get him set up, evaluated, and
I think I included in here.
So, I mean, I can recall it in 30 days, but I don't think the evaluation is going to be done in 30 days.
right.
All right. Well, let's do 45 days. Norma, can I have a 45-day reset on Gustavo Jimenez, please? Is she ever there?
Stepped out for a moment.
All right, let me give you the 45 days.
Wait, let me file this with Ms. Elizondo before I.
Of course.
And I'll take a copy upstairs, Dr. Chamiso about it.
Okay, cool.
And then we'll keep you in the loop. That way you can be available during the interview and all that.
Oh, great. Yeah, yeah, thanks. Appreciate that.
I'll put you down for April 16th.
Okay. make a copy.
Got it down, Judge.
Perfect.
All right,
Thank you
we'll
so much.
see you back then.
You can
Big
take it
round.
with docket.
Yeah.
Yes.
And make sure that you all are in touch with Dr. Scott. All right, thank you.
What was it, 45 days, Judge?
It's April 16th. Yes, and that's a status.
On Renee's client.
Yes. All right.
He was here. Renee's right there. And then Prater reached the back.
And are you already on Attorney Matos' client? She's asking for early term, or is that with somebody else? Is that with him? Okay. Adriana,
Yes, ma'am.
on this one, do you have the motion?
And which one, Judge?
The motion for early term on Juarez?
I don't know if I have it in file.
No, I didn't see it in there. I may be missing it.
I could-
All right, thank you.
Jared, we just asked about Andrea Matos's, but
Yes.
that's a big case. I'll call and pick.
Oh, he said he's doing it.
Oh, okay.
Sure, thanks. All right. And State, have you had a chance to review the motion?
Yes, Judge.
All right. And did you all confer with probation about whether they're in agreement for early term?
Judge, everything is fine. with probation.
All right, so probation, you're in agreement with early term? All right, we're gonna go on the record. Court is calling DC 2022 CR 10228, State versus Julian Juarez. Can I have parties announced for the record?
Jeffrey, you're for the state.
Andrea Matos for defense.
And Mr. Suarez is by Zoom as well. The defense has filed a motion for early termination of this case. State, are you in agreement or do you object to early termination?
We object at this time, but we also have some information to, regarding the complainant, for the court's information.
Okay. Well, before you give that information to the court, do you want to zoom in so you can let the defense know what the information is? Or do they already
I
have?
conferred with her yesterday about it.
Okay. All right, then what I'll do is I'll start with probation. Probation,
Yes, Judge.
with regards to the request for early termination, has Mr. Juarez completed all of the conditions?
Yes, he has, Judge. He has completed, the parenting class. You gave him credit for the community service hours. He's paid off his supervision fees, court costs, and fines completely. Um, he has everything, he's done everything on this part, Judge.
Okay. And have there been any previous motions filed for revocation?
For revocation, Judge, no previous, no, no previous filings of any MTRs. There's not been any compliance hearings or anything like that. We have filed an early termination twice before, and each time those were filed, the state objected and they were, denied.
All right. So, defense, it's your motion. You may proceed.
Yes, Your Honor, thank you. So as probation has stated, he has completed everything. I was just recently hired for the motion to early terminate. I was not there at the previous ones, so I don't know why the state was, I guess opposed to the motions to early terminate, but I know that Mr. Juarez has done absolutely everything during probation, has always shown up to every meeting, has done every drug test or anything that's been requested of him. Even, for example, his child was in the hospital with RSV yesterday and he showed up to court. He was on time. I think he was even early. Like, he has always put his best foot forward while on probation. And so we are just asking to terminate early so that we can, so that he can continue, being a productive member of society. And I think that he's done everything on his end to do that.
All right, thank you. State,
Well, firstly, regarding the complainant, direction of the court and defense counsel, I called the complainant yesterday and informed her about the motion. Her only question was regarding what would happen to the no contact order. I informed her that the no contact order is a condition of probation, and if probation is terminated, that no contact order would go away. But she did say that, I mean, she hasn't been bothered by the defendant. And ultimately, when I asked her what her position was regarding the motion, she wasn't opposed to it being granted. And so she did not mind if he was early terminated. Our only concern is the fact that he's got 4 at-large family violence cases that are still pending. From July of last year and from January of last year, 2 ABI seconds, terroristic threat, and then an abandoning and endangering a child. And so that would be our only reservation regarding early termination.
so here's one of my problems with that. One, I don't know why a case, and I know it's not your fault. I don't understand why a case is up there somewhere that's a family violence case for over a year. And I don't know what anyone expects me to do with that because I don't have any information on that. I don't have anything that those cases have been indicted, that they're going to be indicted. Nothing is presented to the court that he has committed those offenses. It's just up there somewhere. So there's nothing I can do with that because legally, those cases, if they exist, are not before the court. And no motions to revoke have been filed against Mr. Juarez. And you say they've been up there for over a year?
Yes, well, the offense dates are from last year. I don't know when the police department filed it, but
So that,
they have been pending for a while.
all right. So those have been up there since 2025. Do you know what month?
We can see one of them to see when
Mhm.
they filed it exactly.
Oh, you can come up. Good morning.
They started sending stuff over in October and November of 2025.
And what's the alleged offense date?
On this particular one is January of 2025.
All right, so it's over a year, and that's not before the court, and no motions to revoke. Am I correct? No motions to revoke have ever been filed against Mr. Juarez?
Correct.
All right. So the court is going to note for the record that the defendant has completed all conditions of probation. The defendant has applied twice before to have his probation terminated. The court denied those early terminations based upon the fact that when they were originally filed legally, the amount of time that is legally required to have elapsed from placed on probation had not occurred with regards to the first request for early termination. The second early termination, the court denied that, and the reason for the courts denying it were: one, the state was objecting to it; two, I wanted to make sure that Mr. Juarez actually understood and internalized why he was on probation and what he needed to do. And there were also some issues with regards to his testing positive of marijuana, but he obtained the prescription for that from a doctor. So that's the reason why the first two early terminations were denied. So the court is going to grant the early termination based upon the fact that, one, he's completed everything. There's nothing else for us to do. Number two, the complainant is not any objecting to it. But I'm going to tell you, Mr. Juarez, you're not allowed to have any contact with the complainant still. Do you understand? You need to unmute, sir.
Yes, ma'am.
All right, you're not to have any contact with her. With regards to other cases, if they exist, the court doesn't have any documentation, no evidence was presented in regards to those cases and what those cases may entail. So the request for early termination will be granted. Is there anything else from either side?
Nothing from the state.
Nothing from the defense. Thank you, Your Honor.
Right. And I'm sorry, finally, for the record, the court will note that the defendant has been on probation since April 11, 2023. All right, thank you.
Thank you, Your Honor.
All right, sir, you may log off. So sometimes when people are on probation, they'll ask that their probation be terminated early, which means they want to get off probation early. They've completed everything. Now, sometimes based upon the nature of the case, I won't grant early termination. It just depends on all of the facts that are presented to me. It would be great if people had a crystal ball and they say, this person will never get in trouble again. This is what's going to happen. But you just can't continue to hold on to people because you just want to hold on to people. And so in that case, he had completed everything. The first time he requested early termination, enough time hadn't elapsed. So when people are seeking early termination, say, for example, if somebody's charged with aggravated assault with a deadly weapon, or even if they're on probation for a drug case, you can't get on probation on Monday, complete everything, and then come back on Tuesday, say, I want off probation. What I can tell you, when I first started practicing, people would do that all the time, and the judges would be like, okay, but nobody complained about it. But now, well, I always follow the law. And if there's some part of the law that says, oh yeah, they can be placed on probation on a Monday and be terminated on a Tuesday, show me the law, I'll consider it. Now, like, for example, the argument they were putting forth that there are some cases up there somewhere, there's nothing I can do about that because I haven't seen anything. So that's where we are. And then in that case, what, I'm gonna hold him for another 6 months. And then for what reason? And probation, they have limited resources. So if he were to remain on probation, even though he had completed everything, he would have to report continually to them. So that's extra manpower when they really could be supervising somebody else. Yeah. So that's how it goes. Yeah, you can do a phantom date. Yes, but they're not gonna release him from the state hospital anyway, but yeah, just do a phantom date.
Oh, Bruno? Oh. Yeah. I gotta. I'll go one from March against Kelly. Can you give me a What is it?
Or, yeah, I see you. SD and Ford.
Sure, exactly. Yes. With all of it, I'll be trying to reach I really work the 379 for us. Yeah, I think it's.
All right, anyone else ready?
No, ma'am, nobody else is sworn in.
Okay.
Nobody else is signed in.
Alrighty. Okay, Deputy Laura, you could build that. The cat thing.
Yes,
I think it's just made out of crates.
the palette.
Mm-hmm. Rick, are you okay?
This is for Michelle.
But yeah, so try that. Oh, there may be some tea in the back. You can make some hot tea with honey. And we have some those styrofoam cups for hot drinks back there. Oh, and you know what else that's back there? Oh, and Rick, there's some emergency back there and you can heat that up.
Got it.
Oh, yes.
Okay.
Okay, if you heat that up and put some honey in it, it really helps.
Okay.
At least it energizes you.
We still have top ups, but people eat it like candy.
Yeah, I know.
That was a question, get a shot. The steroid shot, and that helps so.
Steroids?
Oh, yeah.
Right, Judge?
Yes, it does help.
You'll feel it like within an hour. They call it a hip, but it's actually your upper foot. Yeah.
Yeah, that's for
It doesn't hurt.
movie is not.
The both up. And she'll feel with everything. And you know, medication, if you can ask for that, it's amazing.
Oh, I love them.
Okay,
She'll look you up at everything.
okay.
I love going. You have their number?
I don't have the number, but I just try.
Yeah, we. Make everybody ready. Yeah.
Thank you so much.
Approach her.
All right, thank you.
This is for one on the docket today.
Okay.
Okay. No.
All right, so have you called her,
Call,
the clinic?
that's why I'm giving this to you now so I can try and get out of here.
Okay. Do I need to call to make that happen?
I'll take care of it. Then. No problem.
Okay. I want you to get well.
Hi, girl. Ford. Andy Ford. And it's a plea, and a plea approved.
Great job.
Additionally, Your Honor,
Yes.
I can, on page one,
Um,
Jesus Suarez Moreno, it's my understanding that,
Oh,
Uh,
page one?
yes,
Okay, yes.
it's my understanding that Jesus, or excuse me, Jose Mejia is gonna go to trial today.
Yes.
Can we get a reset on Jesus Suarez Moreno?
Okay, let's bring him up. All right, the party's on Jesus. Hello. All right, let me pull this up. So here's the thing, you need to make sure you're on time for court, okay?
Judge, if I may interject, he was waiting for him at that end over there.
Okay,
And I walked in, I didn't see him over there.
okay.
He was here.
All right, just make sure you're in the court, okay? All right. So Norma, on this case, I need a jury trial date. All right, your jury trial date is going to be April 14th. You're not going to trial today because we have another case that's going to trial today. All right, once you sign the reset form, you are excused.
Thank you,
All
Judge.
right, thank you.
Judge, I'm ready to go to trial, but I'm glad it's got reset because Tomorrow is my mom's 91st birthday.
Oh my gosh, tell her I said happy birth month.
I'm glad that I can spend a little time with her.
Oh, no, spend a lot of time
Glad it
with her.
worked out the way.
Okay, all right, thank you.
She's kind of getting real bad dementia and next year she may not know I have it. So.
But you know what? She'll feel the love, right?
Well, yeah.
So that's good. Yeah, enjoy the day with her. I hope you're planning on taking off the full day. Don't worry about this because this will always be here.
We'll spend plenty of time with her.
All right, well, you tell her for me, happy birthday.
I'll tell her.
Okay.
Thank you.
I'll wait, I know where I should.
It's the same individual.
I see. Thank you.
You didn't sign it? You didn't sign it?
No, he's not. Bye. I hope you feel better. I hope you feel better, Rick.
Yes. Bye, Rick.
Bye-bye.
Make sure you call. We did need those, that's what you got it marked in. I know. Oh, look, they're here.
LaShawn, since it's Black History Month, I hope he's not leaving on the midnight train to Georgia. He'll be back. Yes. All right, Norma, if you'll call Charles Blanc.
You don't have any announcements for them or anything, Judge?
Oh, we're gonna bring them in we're doing jury selection this morning.
Oh,
I'm just waiting for Charles.
okay, no problem. They're for you then. Thank you.
Thank you.
No, I didn't. I don't know which one.
Here.
Okay.
No, we're not.
Are you getting ready for the jury?
Okay.
I'm gonna get the support. We have two pleas that Adriana's working on.
Okay.
Yes. Okay, that's what I was gonna ask, like, if I guess. Make it click them out. Okay.
Hey, Denise.
Hey, morning, Jeff.
Good morning. So,
I have one, he's still in the state hospital.
yes, so they told me that the commitment was extended
Correct.
till, I think, November 2026. So I just set it for January 2027.
Okay,
Yeah.
sounds good.
Yeah, because it may be, oh, you. It may be a situation where maybe he'll never regain competency. I don't know.
Yeah. And we'll go from there.
All right, appreciate you, Judge.
All right, thank you.
Thank you.
You actually have Ms. Ford, she's ready, she has no more. Everything.
Oh, yeah.
Connor,
Yes,
good morning. Charles, he's pleading a guy in the
okay,
175th, and then he'll be on his way.
okay, awesome.
Okay.
No, I don't.
I'm gonna make a copy from him in the back.
Yes, that's, they didn't, when I signed it, I put it on there or something. Yeah, I gave it back to Rick. That's what I
He's
did.
not here. He's there.
That's TV stuff.
Who's here on Angie Ford? If you'll come forward, please. And are there any applications?
No.
All right, probation, there are no applications. Court is calling 2025 CR 005635, State versus Angie Ford. Can I have parties announced for the record?
Dwight Chumley for the defendant, Your Honor.
And are you Ms. Ford?
Yes, ma'am.
All right, counsel, you received all discovery. Did you review it with your client?
Yes,
Court will find that the state is in compliance with discovery. Ms. Ford, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
yes,
State, are you proceeding on the indictment as presented?
Yes, sir.
Both counts?
Oh, I'm sorry. State moves to waive count 2 and proceed solely on count 1 of the indictment.
Any objections?
no,
Ms. Ford, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. So you are charged in count 1 with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes,
Ms. Ford, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Oh, yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, State is waiving count 2. They're proceeding on count 1. Punishment is to be assessed at 2 years in the state jail facility. There's a $1,200 fine and no applications. Did you understand that to be your plea? Defense?
Yes, Your Honor, we also have agreed to run concurrent with the other case that's pinned. The motion will vote this.
Is that correct?
Yes, sir.
All right, and state, is that the plea? All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No,
Outside the agreement, the state is requesting that there be no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
no objection.
All right, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
Your Honor, my client has been very cooperative. She was on probation with you for quite a number of months. She received help at SafeP, which she has told me over and over how grateful she is to have gone through that. This is on her pending MTR.
Okay.
And that she wants to thank you for letting her do that. And she spent 399 days, something at SafeP.
10 months.
She's completely satisfied at her spot there. The day she finished it is the day she got picked up on the warrant for the new case.
Okay.
But life provides you rewards in other ways, and she's gonna really be great when she gets out.
Okay. So let me ask you all, is there any restitution that's owed or no? All right, then the court is going to follow your agreement, sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $1,500 fine, time and money to run concurrently. There's to be no contact with the complainant. And this will run concurrent with 2021 CR 4750. Next, we're going to proceed with 2021 CR 4750. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Angie Marie Ford who was placed on deferred adjudication in 2021 CR 4750 for the offense of possession of controlled substance, penalty group 1, 1 to 4 grams, on July 20th, 2021 for a period of 3 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 25th day of April 2024 in Bear County, Texas. The defendant, Angie Marie Ford, committed the offense of theft of property greater than or equal to 2,500, less than 30,000 in violation of condition number 1.
To that, how do you plea?
Uh,
True or not true?
True.
State will waive the remaining allegation.
All right, any objections to the state's waiver?
No objection.
Would you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Sure.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, proposed motion finding this court and sentence to 2 years in the
That's our agreement. Your
All
Honor.
right. Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right. The court will follow your agreement. The court will sentence you to 2 years the court is going to revoke, find you guilty, sentence you to 2 years in the prison. Was restitution ever paid to the complainant in that case?
Judge, I don't have any restitution listed.
All right, there's to be no contact with Richard Osborne. Or the court will give you credit for any time served, credit for any time served for successful inpatient treatment. This will run concurrently with 2025 CR 005635. Is there anything else with regards to sentencing in that cost number?
No, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and because your other matter is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you, okay?
Thank you. You would, Your Honor, one more thing.
Yes.
What is this?
It's an apology letter to my family, that I wanted to thank you, because without you sending me to that program, I wouldn't be able to, reach out to my kids again. They're 23 and 27, but it's an apology letter to my family that I'm gonna, for them. But I just wanted to thank you for giving them their mother back.
Oh, you're so welcome. And I'm so sorry. Sometimes cases just drop on us. And if we would have known about the case beforehand, then that could have been taken beforehand. But here's the thing. This is just another bump in the road, right, of life, which happens to a lot of people. But you're going to have to stay on track with where you are. And don't let this derail your sobriety or derail the newfound relationships you have with your children, okay? When you're released from prison, if you can't find a sober living home or something of that nature, and I'm still here, just come back here. I'll pick up the phone and call somebody.
That's what I would like to do, is find a faith-based transitional sober living place to be able to get back on my feet. I've got my peer support certification while I was in SAP to run peer support programs.
Mhm.
And the peer recovery specialist is what I would like to do to help women like me get back on their feet and be productive women in society again.
Well, stop
And
by.
that is due to you. And I wouldn't have received that program if you would have given it to me any earlier. I was ready for it. And I want to thank you so much for making that decision that I couldn't make for myself.
Oh, you're so welcome. And it's going to be great, right?
Yes.
Yeah, you have a lot now that you're clean and sober. Is there something for me?
Yep.
Ah, okay.
Thank you.
Thank you,
You're
Judge.
welcome.
All right, good luck, Angie.
Go have a seat, man. We'll take
Have
you
a
right
seat
now.
right back in the jury box, okay? We'll be right with you.
All right, who's here on Linda Flores? Thank you. Hello. All right, the court is calling 2024 CR 0492 State versus Linda Flores. Can I have parties announced?
Martin Gatto, attorney for Linda Flores.
And are you Ms. Flores? Yes, ma'am. Did you review the document entitled State's Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Probation with your attorney? Yes. And did you understand it? Yes, ma'am. Are you the same Linda Rose Flores who was placed on deferred adjudication in 2024 CR 0492 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on April 15th, 2024 for a period of 4 years? Is that you? Yes, ma'am. All right, state.
Violate condition number, and this is I'm sorry, on Steve's motion dated May 21st, 2024.
Okay.
Violated condition number 45, on or about the 19th day of May 2024 in Bear County, Texas. The defendant Linda Rose Flores did then and there fail to successfully complete residential treatment at the Lifetime Treatment with Pay It Forward Sober Living as directed by the court in violation of condition number 45.
How do you plead to that? True or not true? True.
And then the motion dated April 15th, violated condition number 4 in Bear County, Texas. The defendant Linda Rose Flores did then and there fail to report to the supervision officer as directed for the months of May through December 2024 in violation.
How do you plead to that? True or not true? True.
State will waive the remaining.
Any objection to the waivers?
No objections.
Did you understand by pleading true to violations 45 and 4? The court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violations 45 and 4? Yes, ma'am. Court will find 45 and 4 true. Is there a proposed agreement?
State would be asking for you to grant its motion to revoke, enter an adjudication of guilt and sentence to 4 years in the prison, and this is grounded in the fact that she absconded from drug court failed to report from.
All right.
Your Honor, respectfully, we're asking you to deny the motion, continue her, and then alter and amend with placement in DDRF and a mental health initiative following that. Your Honor, when this case was originally picked up, when she's placed on deferred, it was a chaotic time in her life. She was homeless. She had, unfortunately, an addiction problem with meth. And then her mother became ill. That's actually what prompted her to stop reporting, because she went to go leave the program and then take care of her mother. This is not a situation where she's been basically picking up new cases or out in the streets. She's been living with her mother and has been her full-time caretaker. Her mother did pass away this past December, however. I think the best way to make sure that these choices, these bad choices, don't get made again is in that structured environment with DDRF. So I'm hoping we can go ahead and place her there rather than just revoke.
All right. So, Ms. Flores, it's the court's understanding, and counsel, if I'm wrong, correct me, please. Felony Drug Court has a dual diagnosis program. So that addresses mental health issues and it addresses drug issues. But it appears from your pleas of truth that you just left. Am I correct in that? So I just don't, there's nothing else I can do. Felony Drug Court is an intensive program and they work with people. And according to your pleas of truth, you absconded. So I am going to find you guilty and revoke. I'm going to sentence you to the 4 years in the prison, give you credit for any time served, and the court will request the therapeutic community. Here's the thing. One, I know you want it to be continued. Sometimes people reach their epiphany, just sometimes it's too late. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? Yes, ma'am. All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Okay. All right. We can go off the record. Here's the thing. When you're released, if you can't find help for sober living, if you can't find help for any type of mental health condition, if I'm still here, you come back here, I'll pick up the phone and call someone at a transitional home that will address any mental health issues, any substance abuse issues, so you can have a placement that can help you. The therapeutic community, I don't have jurisdiction to force them to accept you in the program, but they'll see in the judgment that I'm requesting that for you and they can help. But you'll have to request it as well, okay? All right, good luck to you. Thank you. You're welcome.
Thank you.
Who's next? I'm sorry, what? Edward Castillo. Are there applications? All right, the court is calling 2025 CR 014704, 2025 CR 014703, State versus Edward Castillo. Could I have parties announced for the record?
Brian McCracken with the state.
Judge, good morning. Frankie Sandoval on behalf of Eddie Castillo.
And are you Mr. Castillo?
Yeah.
All right, counsel, in each of the cause numbers, did you review the document entitled trial court did you review all of the discovery?
We did, Judge, in both cases.
All right. And you reviewed that with your client and you received all discovery?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Castillo, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each cause number?
We do, Judge.
Mr. Castillo, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, in each cause number, you're charged with assault of hospital personnel on hospital property as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you're giving up those rights?
Yeah.
And did you intend to give up those rights and enter into a plea in each cause number? All right, counsel, I don't have the application for community supervision. You're all applying for probation, correct?
Yes, Judge, and I apologize for that.
All right, if you'll grab them and sign those.
Thank you, Judge.
Okay. Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Castillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's $1,000 fine to be probated, and the cases will run concurrently. Did you understand that to be the plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney in each of the cause numbers? Did you sign it in both places? According to, signing and entering into this plea, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, were there any such motions?
There have not been, Judge.
All right, outside the agreement, the state is recommending that your community supervision be for a term of 10 years. They're saying no contact with Methodist specialists in transplant, anger management, MRT. They're asking for inpatient treatment for what?
Judge, this all stemmed from an emergency detention, while he was being detained.
No, I mean, you all are saying inpatient treatment. I'm trying to figure out what program are you all suggesting?
Safety, Judge.
All right. And there's to be no contact with the complainants. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
In each cause number, did you review the documents entitled trial court certification? I'm sorry, in each cause number, sorry, Cindy, I'm gonna slow down. In each cause number, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Honor. No objections, Judge.
All right, in each cause number, the court will find there sufficient evidence to find you guilty. The court will find you guilty in each cause number. Was there a referral? Do y'all think there should be a referral to the mental health court?
Your Honor, this was a bad evening for Eddie. Medication was an issue. Since he's been incarcerated, medication has been stabilized. I've been working with Eddie for a little bit over half a year and seen a drastic change in him. We believe, Judge, subject to the court's approval, that SafeP would address what's needed with respect to Eddie at this time.
All right, so do y'all want him referred to felony drug court? I'm sorry, not felony drug court, referred to the mental health court. Because if I'm looking at this, this is an emergency detention, which suggests to me there was some sort of mental health crisis.
The events giving rise that evening, yes, Judge, over at the hospital.
So do y'all want to have him referred to the mental health court? That may be the appropriate placement. Because as far as him going to SafeP or anything of that nature, he would need a TAP evaluation for that anyway. I can reset this, reset it for a TAP evaluation so we can see if SafeP is appropriate. They may say it's not. And then we could do a referral to the mental health court. And with the referral to the mental health court, of course, the state would have to agree.
Yes, Judge.
But the facts that I'm reading, he was suffering from a mental health crisis or in crisis, and that's why there was an emergency detention. And during the emergency detention, personnel was injured by him. So is there any objection to resetting this for him to have a TAP evaluation done? Because they may say SafeP is not appropriate for him, and then do a referral to mental health court.
Your Honor, on behalf of Eddie, no, there would be no objection. He's seeking whatever assistance he can to overcome these demons, because as the court is aware, the mental health issues bring along other potential difficulties.
All right, so what we'll do, Ms. Abrams, we'll set it for a TAP evaluation. And if the mental health court accepts him, then they can do the TAP evaluation. All right. All right, so we'll reset this for the TAP evaluation. How long will that take?
Judge, I need.
All right, so we'll recall it in 4 weeks. Norma, could I have a date?
March 18th.
And Judge, for the record, and I apologize, Judge, I may be out of town until the 18th, if it's possible to do the next day or the following week.
Okay, sure.
Okay, thanks.
23rd.
All right, we'll set it on the 23rd.
Thank you, Judge. And for the record, Eddie and I have discussed that even though he is agreeing, because of the state's generous offer to community supervision, there would still be a requirement for him to remain in custody while we go through this process. So
Yes.
he's aware of that. And then also, Judge, for the record, just to clarify, motions were filed, but nothing was ruled upon. They were just discovery motions, et cetera.
All right, thank you. So what we'll do is we're going to bring you back on March 28th, and we will have referral to mental health court and see if they accept you. Maybe they will, maybe they won't. The state has veto power with whether or not you're in that program. But it won't be in vain because we'll still get the TAP evaluation done.
I stayed on the same track.
Okay. Thank you so much. You're welcome.
Judge, what day was that?
I think you said March 28th, right, Norma?
No,
Oh, sorry, March 23rd.
On that date, they have that mental health conference. Do you want me to?
Oh,
I just looked it up right now.
yes, put it after the mental health
The
conference.
30th, which would be the 30th.
All right, we'll put it down for the 30th, but of course, counsel, if we know before then that they're accepting him, we can still move forward with the mental health. It's just that on that date, I have to go to the mental health conference.
Thank you, Judge.
All right, thank you.
Right back in the box.
And Your Honor, for the record, if I could present the applications for community supervision on both matters.
Yes.
Thank you, Judge.
All right, thank you.
And may I be excused?
Yes,
And we're off the record, Judge?
yes.
Okay, so it's a mental health conference that you're attending as an attendee, not.
As an
because you're
attendee now, yeah.
yourself.
Oh, but you know what? I tell you, I 100% believe in therapy and everything. So whenever I call someone and I want some therapy time, I'll call them and I say, hello. And I'll say, excuse me, I want to lay on your couch for a little bit. So I just talked to them about my day.
Judge Ms. Field just left, but her and I were very good friends with Michael Valasek, and actually Michael Valasek was my therapist. We would have
Oh,
lunch.
he was so awesome.
So a week, and
Mhm.
just have folks to bounce things off of, and
But no, he's an awesome
yeah,
guy.
yeah,
He
we're,
was an awesome
we're
guy.
losing too many of us, Judge.
We are.
Take care, Judge.
All right, you too.
Any issues for today?
Yes. All right, everyone, we're starting the trial. Is there anyone else who's ready?
Yes, ma'am, I have one thing I'm starting to, I'm gonna go and swear them in, and then, I don't have anybody else up that. And do you have somebody too? I don't have.
Yeah, we're ready on the
On the inside.
Okay. All right, as soon as Charles Blunt comes, we're gonna
I didn't know.
do jury selection. Hi, hello, sure.
I was here last time, I wanted to speak to you, but you were in the middle of a trial.
Yes, I just wanted to say hi to you. And I love your rulings,
Oh,
and I know your sayings.
oh, thank you. So, well, welcome to Bear County.
Thank you so much. I appreciate it.
So what law school did you attend?
At South Texas.
Okay, awesome.
20 years ago, and my son is at South Texas now.
Ah,
Yeah.
what, is he studying law as well?
Yes, he's studying law.
Well, anytime he wants to come visit, have him come down.
I will, because he lives here and he goes to school online. So he's here. So he might, yeah. So I just wanted to let you know, I mean, I know all you're saying.
Oh,
So I just appreciate, you know.
oh, thank
Yeah,
you so much.
It's a good standard. Also learn from it to use.
I was unplugged, I was like.
Okay, awesome.
Nice meeting you.
You know what? I learned that there's a nice, because I had to go to Houston one time and the flight round trip was over $1,000. So I ended up taking the Von Lane. Have you ever heard of the Von Lane? Oh, you should, if you're coming
Make sure
from
you-
Houston, for clients you have here, look into the Von Lane. It was a nice experience. It's VONLANE. Yes. Yeah. All right, thank you. You too. Have a good one. Oh, do you have a card?
I think I do.
Okay. I can never deal with Houston traffic. I'm always so afraid.
You gotta have a pick.
Hmm?
We're gonna have a pick.
A pick.
Sure.
Oh, okay.
Thank you.
Let's do it.
Hold on.
This is MTR.
Oh, shoot.
All right, the court is calling 2023 CR 7159 State versus Stevie Ray Stokes. Could I have parties announced?
Kelly put over Mr. Stokes.
And are you Mr. Stokes? All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
No, just not the ISF part. You know, if
Stevie,
That
did we,
makes sense.
did we go over the MTR?
but,
All right, so let me explain something to you. I don't know what type of agreement you all have maybe worked out. But these motions to revoke, when you're on probation, is a contract with the court itself. Any agreement that's worked out by the state or the defense, I don't have to follow it. So what I'm trying to get at right now is this is your motion to revoke. All right, did your attorney review the motion to revoke with you?
no,
Okay,
all right. When we reset, I gotta go to Carnes.
sure. All right, Ms. Ferguson, if you can recall this for Thursday. All right, we'll see you back on Thursday.
Thank you.
Thank you. All right, thank you. All right, who's the other person with the all right, Austin Rodriguez. All right, if you'll come forward, please. Court is calling 2025 CR 0122329 State versus Austin Rodriguez. Can I have parties announced for the record
For the state.
for the defense?
Good morning, Judge Alfonso Cabañas for the defendant.
And are you Mr. Rodriguez? Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there's an application. Did you review the application for community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Mayor, state moves to waive the habitual enhancement.
Any objection?
No objection, Your Honor.
Oh, my pen just died. All right, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with unlawful possession of a firearm by a felon? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Rodriguez, did you understand? I'm sorry, just one moment. All right, Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $2,000 fine. The state is opposed to your application. They're taking in consideration 2025 CR 012326. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
One and off.
No objection to state's warning attachments.
Right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right. Senate, PSIs are taking about 12 weeks. So if you want a full PSI, I'll give you a reset date in 12 weeks. Or if you do not wish to have a PSI, but you want a chance to bring witnesses in, I can give you a shorter reset.
I do have quite a few characters taken.
Oh, you just let me know. That's, I mean, if you, I'll reset it in 12 weeks. That means that probation will interview you. They'll give me your criminal history background and anything that anyone wants to say. That's what's in the PSI. Your attorney can explain it in more detail to you. That's 12 weeks. Or if you want. Oh, I've been told it's 6 weeks.
Yes,
So we bring you back on April 2nd. If you want to come back sooner, April 2nd?
Yes, Your Honor.
All right, so we'll bring you back on April 2nd. Counsel, is there a need for a TAP evaluation?
No, Your Honor.
All right, so we'll bring you back on April 2nd. Someone will come visit you at the jail to interview you, okay? All right, thank you.
Thank you, Judge.
Dicker. Yes. Yeah, so
If the suckers were ending in 8386 for the office of murder.
all right. Can I get the indictment on that case?
Yeah. For
The murder case?
Yeah, I can't keep it. Can I keep it? No problem. I don't think so. I think it's from the file. Yeah. No. Not
All right, thank you, you too.
I have several.
On the murder case.
On the one for murder?
Yes.
Okay. Did we do an election? We need to do that. Your cards.
Oh, yeah. It's supposed to be done on Friday.
Did you take my tape?
Yes, I did, because I need it.
Sorry, you don't need that.
Okay.
Just give us a moment, Judge. We set it up. We're still not.
Guys, before we go on the record or anything, how much time are y'all requesting for jury selection? Charles, thank you. Oh, Charles, have you all done? Okay. And so there's nothing to enhance this, so the range is 5 to 99 or life? Okay. And this is 2002 8385? Okay, this is the wrong.
Okay, I got the attempt one. I'll get you the number.
Thank you.
Cindy, do you still need that? The mic over here?
Oh, and guys, when we're doing selection, if you guys could just consciously not stand in front of whoever is speaking, because it blocks Cindy and it makes it harder for her to hear. And then if you guys, Cindy has the mics that are for you guys so she can hear. If you all will make sure that's on your lapel.
Surveillance. There's that somewhere.
Is this yours? Oh. Yeah.
How many do we have?
75.
Are we all the rows or are there empty rows?
They're all gonna be used by the assembly. I already have chairs for them in the
Okay,
corner.
let me go grab them.
I already talked to them. I'll go get them.
tell them.
All right, thank you.
Because I need to tell them, make sure that they understand they can't talk to their family member.
Okay, thank you.
Document says you have, says we have the right to appeal because it's a trial, so sign right there. Now, the last thing we have to do. And I, the day I mentioned, I told you. This was back in 2002. Yeah. I was the prosecutor side. Okay. Okay. Right? Okay. And then Lindsay, well, she can't work for me, she can work for this board, but she knows touching. You give both of those. Just when the report comes back, can we get something on the record real quick with my client?
Sure. And do you want me in or
I'm
out?
just saying, it's just about the waiving conflict that I was in the 187th back while this case was originally pending,
Okay,
and that Lindsay was in the 187th prior to.
okay.
But we told him that the day we met him, and he's fine with him, obviously.
Okay. All right, I'll call the case and then we can go on the record. All right, everyone, please be seated. All right, everyone, good morning. All right, your reaction time is down, so we're going to work on that. Good morning, everyone. Yes, everyone is wide awake. So you are here in the 187 District Court. You're on the 4th floor, and I am Judge Boyd. So what floor are we on? All right, what's the court number? And who's the judge? Now, you're probably saying, we know where we are. Why are you asking us that? And this is why I've learned to ask jurors those questions, is because anytime we take a recess or break, you all have to leave the courtroom. You can't say, well, I don't need a break. I'm just going to stay behind. No, everybody must leave the courtroom. And it always happens when people leave the courtroom, they get lost. We once had a juror who was trying to get selected on another panel and we had to search for them. Then we have other jurors say, I looked up and everybody was gone, so I didn't know. So if you ever get lost or you look up and everybody is gone, if you see or remember the numbers 187, just tell everybody I need to be in the 187th. In all of Texas, you will not find another 187 district court because 187 just signifies this was the 187th district court that was created in Texas. So no matter where you travel, 187. Or if you remember the last name Boyd, I'm the only Judge Boyd in Bexar County. So they'll be able to tell you where you need to go. So this case is the state of Texas versus Mr. Mejia. To my left is the court reporter. She takes down everything that everyone is saying. So the tone that I'm using now, please use this tone when you are speaking. Does everyone understand? All right. Is everyone in the back able to hear me? All right. So if for any reason I'm talking, the defense is talking, or the state is talking, and you cannot hear, raise your card. Once you raise your card, they'll call your number and you can say, I can't hear you. Can you speak up? Will everyone promise to do that? So I'm going to have the state introduce themselves to you for the state.
Good morning. My name is Megan Galloway and I represent the state of Texas.
Morning, my name is Jeffrey Wright. I also represent the state of Texas.
For the defense.
Morning, I'm Charles Bunk. I'm defendant's lawyer.
And I'm Lindsay Shaw. I represent Mr. Mejia and I work with Charles.
All right. And Mr. Mejia, would you introduce yourself?
My name is Jose Mejia. I'm the defense.
All right. So we have other people in the courtroom. So you have the deputies, the clerks. When you see people come through this door, it's for things for me to sign. It has absolutely nothing to do with this case. It's about other cases. So you can ignore that. When you see people coming to this door, they're coming through that door because they did not read the sign that says we're in a jury trial. Please do not come through that door. Sitting here, which is the witness stand, these are students and interns. Some of them are from my class at UTSA. So you may see them here. They are here to learn about this process. But we also have other people who are here. Mr. Bunk, who are the people back here as well?
Defendant's mother and his extended family.
All right. So what I can tell you is the people who are here, They're not going to speak to you. My students are not going to speak to you. They're just here to observe. Does everyone understand?
Yes.
All right, so you have something very valuable in your hand. They are cards. Please raise those numbers. And once I tell you to lower the numbers, you may lower the numbers. All right. Jurors 1 through 21, please lower your numbers. The other people who have your numbers raised, the acoustics in the courtroom are bad. What I'm going to ask you to do is something very important. Every jury that we have had has failed at this, but I have faith that you can do it. If somebody is asking you a question, or if you have a question, you raise your card. And when you get ready to answer, if you are able to, please stand when you speak, because that will help Cindy be able to hear you. Is everyone able to do that?
Yes.
Is anyone not going to be able to do that? I have faith that you will do that. All right, you can raise your card. Now you can lower your cards. That was the test. That was sort of like Simon Says, right? All right, so the parties introduce themselves. Is there anyone here who recognizes anyone from the state or the defense? All right, can you raise your card, please? That's number 6. Who do you recognize?
Mr. Charles Buck.
All right, thank you. Anyone else? Is there anyone here who recognizes Mr. Mejia? All right. Now, when I speak to you, and when the state speaks to you, and the defense speaks to you, they're going to be talking in hypotheticals. They're not allowed to tell you what they think this case is about or what they think the facts are. You will only know what this case is about and what's going on if you are selected to be on the jury. So when they speak to you and when I speak to you, don't think, oh, I know what the evidence is in this case. I know what's going on. Don't be Mrs. Kravitz from Bewitched. You will not know what is going on until you're on the jury. Does everyone understand?
Yes.
All right, so the charge in this case is the charge of murder. Just one second. Okay. The charge in this case is murder. So I know sometimes people say, you know what, I would love if I would be called up for jury duty on a case on the civil side or something else. But we need jurors so that we can have jury trials. So when you have felony cases, people come to court because they've been indicted. Now, what is an indictment? An indictment is just a sheet of paper, and it is to give knowledge or let someone know who's being charged, what they're charged with, and where they need to be. So, for example, raise your card if you've ever had a traffic ticket. All right, so this is what I can say. You all are some of the worst drivers that we've had. All right, you can lower your cards. I've had a traffic ticket before. I was about 18, 19, something like that. And here I am, 21, and I still think about that. So when I received my traffic ticket, it was at the time where officers had the paper book and it was carbon copy, and they give you your copy and they keep theirs. Now, my understanding, they do it some sort of electronic way. So let's say that you're driving and an officer pulls you over, and the officer pulls you over and they tell you, hey, you ran a stop sign. And they give you a ticket saying, here's your ticket, you ran a stop sign. Now, on that ticket, it will tell you the officer's accusing you of running a stop sign. And usually for municipal things, they'll have on there what the range of punishment is. Like it's some sort of fine. You can mail in $100 or whatever it is now. Or you can come down to the court, and sometimes it's municipal court on Frio. When you accept that ticket, you're not telling the officer, yes, you're correct, I ran a stop sign. That ticket is just to tell you what you're being charged with. Because wouldn't it be bad if you think, okay, I know I didn't run a stop sign because there's no stop sign here. Let me go down to municipal court and I'm going to fight this. And then you get to municipal court, you're sitting before a jury, and then they drop it on you. Yeah, you're here for running a red light. So indictments, all it is to give the person who's accused knowledge of what they're being accused of. It's not evidence of anything, and it cannot be considered by you in any shape, form, or fashion in deciding on whether Mr. Mejia is guilty or not guilty if you're able to come to a conclusion. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Mejia because he's here charged under indictment? All right. Now, the next thing I want to talk to you is about certain rights that people have when they're charged with an offense. One of them is the right to remain silent. Has everyone heard of that term before? Where are my Beretta people, Mannix? All right, paper chase practice. Now, this is what that means. That means that the state can't call somebody who's accused to testify. The right to testify solely rests with the person who's accused. I've been a defense attorney. I've been a prosecutor. There are many reasons why maybe someone who's accused of a crime who wouldn't want to testify. For example, sometimes people are afraid of speaking. I had clients before, I'm like, you're just talking to me and you're looking all nervous. You wouldn't be a good witness. Sometimes it's the person maybe has a speech impediment. Sometimes maybe their attorney tells them the state then proved their case. There's no need for you to testify. There are many reasons why a person would not testify. And I will tell you, I've had jurors before where saying, well, if it were me, I would do this and I would do that. And I always chuckle inside because I'm like, it's not you and you don't have, advice from someone, maybe advising you what you should or should not do. It's similar to if you go see a heart surgeon and they say, we need to do surgery, or they say, oh, we don't need to do surgery. And you say, well, I know that's the advice you're giving me, but I'm going to do surgery, or I'm not going to do surgery. Usually when people have experts who are talking to them, usually they follow their expert's advice. But the key about the right to remain silent is if Mr. Mejia decides to exercise his right to remain silent, you can't hold it against him. You can't deliberate and say, well, he didn't testify, so that's a strike against him. Or I wonder what he would have said. You're not allowed to do any of that. You're not allowed to consider it at any point in time, discuss it or anything. Does everyone understand? Is there anyone here who's going to hold it against Mr. Mejia if he decides not to testify? All right. Now, the next thing I want to talk to you about is presumption of innocence. Yes, number 14.
Can you speak up just a little bit louder?
Thank you. See, I appreciate that. All right, the next thing, that better? Okay. The next thing I want to talk to you about is called the presumption of innocence. What does that mean? That means that anytime someone is charged with a criminal offense, they are presumed to be innocent. So what goes along with that? That means if they're presumed to be innocent, that means that they don't have to produce any evidence at all. So in criminal cases, the state has the burden of proof, and they must prove their case beyond a reasonable doubt. The defense does not have to do anything. And in law school, how our professors would explain it to us, they said, you can sit over there, play crossword puzzles, you can play spades, Uno. But they wanted us to really understand that as a defense attorney and someone who's accused, it is not their job or their obligation to prove their innocence because they are presumed to be innocent. It is the state's job to prove their case beyond a reasonable doubt. Does everyone understand? All right, so you understand the defense does not have to prove anything. And if you start saying to yourself, well, the defense should have done this, they should have brought this evidence, or they should have brought that, then you've shifted the burden to the defense and the burden rests with the state. Does everyone understand? Yes. Now, proof beyond a reasonable doubt. What is the definition? When I was in law school, we had to know that definition forwards and backwards. I learned it. My very first jury trial in 1997. I said it without stumbling. I knew where to put my commas. I knew where to put the exclamation point. I knew where to pause. for dramatic effect. Now, after I tried my very first case, guess what happened? There is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can give you a definition because there's no legal definition. So when I was a defense attorney and a prosecutor, I said, well, how do I explain this to people? So I explained it to them by telling them what it is not. Next door, you have the historic courthouse. It's the courthouse with the green rooftop. They try civil cases over there. Civil cases like maybe fender benders, anything to do with money. It's tried over there. Now, that burden, when you have those type of cases, is preponderance of the evidence. It's more likely than not that something happened. If you're ever deliberating in a criminal case and you're deliberating and you say, you know, I think this happened more likely than not, you know, you are at the wrong burden and you need to mentally click and say, oh, I'm in the civil courthouse with my mind and I'm supposed to be in the criminal side. The other burden they have over there, which is their highest burden, is the clearing convincing evidence. Clearing convincing evidence is the burden that's used to terminate parental rights, where they say you're a danger to your child, so you will no longer be this child's parents. That is their highest burden. Here, the highest burden in the land is proof beyond a reasonable doubt. So proof beyond a reasonable doubt is higher than any of those burdens. Does everyone understand? Now, I want to talk to you about fairness and what fairness means. I'm going to give you a hypothetical. Let's say you knew you had jury duty today, which you did because you're here. And the night before, because you want to be on time, you drive downtown because you want to map out, see where the construction is. And I'm sure when you arrived today, you found out there were new constructions that was not there the night before. But you made this plan, you get up early, you cook your breakfast, you're going downstairs. And when you get downstairs, you find your vehicle is on cinder blocks. But you're doing your civic duty. So you say, you know what? I'm going to get the Via bus, or I'm going to call an Uber, or my next door neighbor is going to take me. You stand outside and you're waiting to be called in for your case. And when you call in, you find out you're here for a burglary of a vehicle. Usually people will do that hypothetical and they'll say, so you really can't be fair, right? But let me just tell you, the correct question is, if that were to happen to you and you find out that the case that you're being asked to serve on is a burglary of a vehicle, are you going to hold it against someone who's accused because your vehicle was burglarized? Or are you going to sit, listen to whatever evidence is presented to you, and make a decision, if you can come to a decision, on the evidence that's presented to you? Does everyone understand? Yes. So that's what fairness means. And I always tell the juror, raise your card if you were born yesterday and slept all last night. The reason why I ask that to jurors is because we all come as a fully formed human being. We all may have traumas in our past. We may all have things that have happened in our past. But in jury trials, the only thing that people want is, can you be fair? And fairness means, if you're selected to be on this jury, can you sit, listen to the evidence, and if you can come to a decision, base your decision upon the evidence that's presented to you. Does everyone understand? Yes. Hearing that, is there anyone here who cannot be fair if they were selected on this jury? Now, the next thing I want to talk to you about is ranges of punishment. There are two phases to a criminal case. Some people think the first phase is the innocence phase, but it's really not. The correct phase, that's phase one, is, did the state prove their case or not? It's not, is someone innocent or not? It's, did the state prove their case beyond a reasonable doubt? Does everyone understand? That's phase one. So if the state does not prove their case beyond a reasonable doubt, what should your verdict be? Okay, everybody's, okay, I don't think that's a hard question. All right, so if the state doesn't prove their case beyond a reasonable doubt, what should your verdict be? And as Mr. Mejia sits here right now, you haven't heard any evidence. If you were asked to vote on whether he's guilty or not guilty right now, what should your verdict be? All right. So that's phase one. Now, there's only a phase two if Mr. Mejia were found guilty or if someone is found guilty. Then you go to phase two. And phase two is what is called the punishment phase. So, punishment phase. Murder. What is the range of punishment? The range of punishment for murder is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Now, as you can see, that is a wide range because when I say 5 to 99 years or life, that means 5, 6, 7, 8, all the way up to 99 years or life. Does everyone understand the range?
Yes.
Now, some people will ask you, can you give this amount? Can you give that amount? Here's the proper question. The proper question is, do you internalize that that's the full range of punishment for murder? Does everyone internalize that's the range of punishment?
Yes.
All right. So I'm going to give you a hypothetical. Let's say you have a couple. Their parents knew that, oh my gosh, you had a girl, I had a little boy, you and I are best friends. Wouldn't it be great if our children got together and married? This would be so awesome. So they were constantly being pushed together. They went to the same preschool. You know, they would give each other little Valentine cards. And they end up getting married right out of high school. And everybody's like, oh, they're such a great couple. They love each other. They go on to have children and their children have grandchildren. As they age, one of the partners ends up getting very ill. And the doctor, they've done all they can. The doctor said, well, we can't do anymore. And you know, the person loves their spouse. So they're just going to any doctor. Hey, can you give me some hope, some hope? And the doctor tells them, there's nothing we can do. And this person is going to be in unbearable pain for the remainder of their life. And the remainder of their life, let's say they say it's 2 months or 3 months, but they're going to be in unbearable pain and there's nothing we can give them to help them with the pain. Now, let's say that spouse like, man, I'm in so much pain. Can you just help me? You know, I can't even lift my hand to take all these pills. Can you just put the pills in my mouth? Give me the water so I can wash it down. Now, that person does that and the person dies. Guess what? That's a murder. Now, that may be a case where you say, you know what? Life is not appropriate in this case. Does everyone understand what I'm saying?
Yes.
So what it is, can you internalize the full range of punishment? And if there is a punishment phase, whatever evidence is presented to you, if you can come to an agreement, you can use that in determining what would be appropriate. Does everyone understand?
Yes.
A lot of times when people think about range of punishment, it never fails. Jurists like, yeah, but I need to know the facts before I can say this. That's why it's not about whether or not you can give it. The question is whether or not you can consider the full range of punishment. Does everyone understand?
Yes.
Yes.
So for the charge of murder, you've internalized what the full range of punishment is. Is there anyone who cannot consider the full range of punishment if someone were found guilty of murder? Okay. Now, the next thing I want to talk to you about is English. I love the English language. I love languages. I wasn't supposed to be in Texas. You can tell where I'm from when I have to say words like all and soul. I'm from Louisiana. So of course I took the only language, even though my classmate, one of my best friends, she was like, Stephanie, please take Spanish with me. And I'm like, no, I'm going to be retired at 22 and I am going to be living in Paris. So of course I took French. And then lo and behold, after undergrad, grad school, I end up here for law school and I'm like, should have taken Spanish. So I'm working on my Spanish. If it's not where it should be, you can blame the deputies. They're supposed to be teaching me. So when I was in school, a lot of my classmates from different countries, they could speak 6, 7 languages. So I can pretty much say hurry up in every language, but I'm working on the other part. So raise your card if English is not your first language. and keep them raised until I call your number. We have 20, 24, 28, 29, 30, 43, and the person behind 43, if you could raise your card higher, please. I can't see your card. 56 and 62. All right, so everyone, I'm going to ask you the same questions. Number 20, what's your first language? Have you been able to understand everything? 24, what's your first language?
Spanish.
Stan. So Cindy can hear. Have you been able to understand everything?
Yes.
Thank you. 28.
Spanish.
You guys got to stand so Sydney can hear. We helping Cindy out. Okay.
Spanish.
Have you been able to understand everything?
A little bit.
All right. What do you mean a little bit?
Some stuff, yes, some, no, a little bit kind of trouble.
So is it because of the legal terminology?
Yeah.
All right. Thank you. Number 29. What's your first language?
Spanish.
Have you been able to understand everything?
Yes.
Thank you. Number 30.
I became French.
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 Yes. Come on,
Thank you.
tell me. Have you been able to understand everything?
Absolutely.
Thank you. Merci beaucoup. All right, number 43.
Spanish.
Have you been able to understand everything?
Yes.
Thank you. Number 56. I'm sorry, which language? All right, have you been able to understand everything?
Yes.
Thank you. Number 62.
Greek.
I love Santorini. Have you?
Everyone does.
Yeah. I only went there because I wanted to say Mykonos and Santorini. Have you been able to understand everything?
Yes.
All right, thank you. All right, the next question I'm going to ask you is, are there any time constraints? I'm expecting this jury trial probably to end by Monday. All right, so is there anyone with any type of time constraints? Now's the time to raise your card. And what I can tell you is after jury selection, we'll start with testimony potentially today. So I'm going to give you guys in time to internalize it. So through Monday. All right, so I'm going to call out your numbers. When I call your number, please lower your card. Number 20, 21, 25, 33. I'm sorry, 30, 33, 34, 38, 51, 52, 70, 74, and 75. Juror number 20, what is your time constraint?
My wife just had an emergency, she had to leave to St. Louis, Missouri, so I'm caring for a puppy that's dying from cancer.
All right.
I have no one else. So.
All right, thank you. 21.
I have a doctor's appointment.
Oh, when?
On Monday.
What time?
8:30.
All right, thank you. Number 25.
I'm doing clinical teaching hours for TEA certification, so I have to be at my school every day to get those hours.
In person?
Yes, I'm teaching.
Did you tell them downstairs that you were in school?
Yes, but the like my class is on Monday, but like the work week is my school, like fully between my hours.
All right, so what days?
Tuesday through Thursday.
All right, thank you. Number 30.
I have to babysit my grandchild,
All right.
so that can go to work.
All right, and what is the age?
He's 2 years old.
All right, thank you. Number 33.
Wife and daughter going on a camping trip, so at least my 5-year-old at home by herself, and we don't have anybody here to take care of.
And when is this camping trip?
Friday through Saturday.
And who's the camping trip with?
It's AHG.
Okay, all right, thank you.
Sure.
Number 34.
Yes, I'm the main breadwinner of the house, and if I don't go to work, I don't get paid because I'm a commission-based employee.
All right, thank you. Number 38.
My wife's gonna be out of town, Saturday and Sunday. I'm not sure if we do this.
Oh, we're not gonna be here on Saturday and Sunday. Unless everybody wants to be here. All right, okay, thank you. Number 51. What time? All right, thank you. 52. All right, 3:20. Number 70.
I don't have anyone to pick up my daughter on Friday or Monday.
Friday or Monday? What's the pickup time? All right, thank you. Number 74.
I do lawn service, my own business, and yeah, so I get busy for me. How much solo operator?
Isn't the grass dormant though?
I got a search.
Okay. All right, thank you. Number 75.
Vacation, Sunday.
And where are you going? Oh, happy birthday. All right, thank you. All right, is there anyone else? Number 46.
I'm the only one that works at home, and we're
All right, thank you. All right, ladies and gentlemen, I'm going to tell you two stories. Both of these stories are true. So the first story I'm going to tell you is about my uncle, right? I realized that jury duty is an inconvenience. I always tell people it's not a sacrifice, it's an inconvenience because one, there's a lot of one ways downtown. And then when you finally see where you're supposed to park, you find out it's a one way. And then you start thinking, yeah, there's no traffic, maybe I can just turn. But you realize you're coming to a courthouse and you decide to obey the rules of the road and you take the U-turn. So what I can tell you is your country only asks two things of you. It asks you to serve on a jury as a juror once in a blue moon. Raise your card if you've ever been on a jury trial and actually heard evidence. All right, that's 2, 10, 19, 20, 24, 36, 41, 51, and 14.
Can you repeat the question?
Sorry, thank you. Have you ever served on a jury trial and actually heard evidence? Have you ever?
Very last part.
All right, have you ever served on a jury and actually heard evidence? All right, thank you. All right, for those who raised your hand, and that's 2, 10, 19, 20, 24, 36, 41, and 51. Raise your card if that was a criminal trial. All right, that is 19, 2, 14, and 20. So 2, 19, 14, and 20 was there. Raise your card if you reached a verdict. All right, 2, 19, 14, and 20. All right, thank you. So of those people, 2, 19, 14, and 20, raise your card if that trial took place in Bexar County. All right, so that is 19, 14, and 20. Thank you. And number 2, where did that jury trial take place?
Los Angeles.
All right, thank you. Now, my uncle went to a school in a small town called Grand Cane, Louisiana. Super intelligent. So the teachers would skip him a grade because they would tell my grandmother, they would say, Miss Lane, we taught him all we could teach him. So of course, when his sisters and brother started going to school, they didn't like that very much because the teachers told them, this is the gold standard. You need to live up to expectations. So what ends up happening is my uncle ends up graduating and there's a conflict called the Vietnam War. And he goes to my grandmother and asks for her to sign for him to join the war because he said with civil rights, there's really no way for me to improve my lot in life here. And I know parents will say they don't have any favorite children, but it's a firstborn, right? And if you remember those times, this whole thing where we have computers and we can message people and we can send videos to people or take a photo and it automatically appears on the other side. That's not the world she grew up in. My grandmother had a television set. It had 3 stations, ABC, NBC, and CBS. And NBC, the weather had to be just right. If there's too much wind, you're not going to get anything. And this whole thing where people saying, oh, there's nothing to watch on TV. They keep playing the same thing. Back in the day, programming ended. And you know it ended. They'll play the national anthem and a flag will be blowing in the wind. My grandmother did have a phone, but it had no numbers on it. You pick up the phone, an operator answers, and you tell them who you want. That's why you had songs like Beechwood 4, 5, 7, 8, 9. Now me, I grew up in the era of the rotary phone. If you look at my index finger, you can tell I did my best to win the prizes from the radio stations. When you got touch tone, you were doing something. You could have hit the redial. But so when she sends her firstborn off to war, of course she has his name and his rank, and you just send the mail. And Grand Cane was a super, super small town. It still is a super small town. So the bigger cities in Louisiana would see their mail way before she would receive hers. And I know it's still because all of a majority of the males in my family serve in the military. And so I know it was like for her the same way it was now, where wherever your boots land, you need to sit down and write a letter to your relative to let them know you arrived on time. So my grandmother knew the one thing you did not want is you did not want the military knocking on your door. My grandmother had a 6th grade education, but she was super intelligent. She babysat me while my mom was at work, taught me how to read, tell time, tell the insurance salesperson, no, thank you, we don't want any. So she knew that's not what you want. And I used to always end that story right there. And then Deputy Laura would say, Judge, what happened to your uncle? So my grandmother did get that knock on her door, but my uncle survived. He came back home. He continued in the military. And then after his military service was over, he did great work. He has since passed. That's why whenever I smell Old Spice, it always makes me think of him because that's what all the military men were wearing. And whenever he would come back from his trips, he would pick me up, hug me. I would smell his Old Spice and he would give me a gift. So I'm always associating Old Spice. It takes me back to that time frame. So I tell that story to tell people that's a sacrifice, sending your firstborn off to war, not knowing what's going to happen. So this is an inconvenience. The other story I always tell people is about my friend. She did civil law. I've always done criminal law. So on the criminal side, we're always in court, always in trial. And she had jury duty coming up. And she's like, Stephanie, I have jury duty. Let's have lunch. I'm like, great. And so we're having lunch. I say, how's it going? She's like, fantastic. And I'm thinking, that's an odd thing to say. I say, why do you say it's going fantastic? She's like, because it's just like law school. I'm on the back row, keeping my head down. I haven't answered any questions. And so I started laughing and smiling. She's like, what's going on with you? I'm like, I'm so happy. She's like, why? I said, because you're going to be in jury duty and we're going to have lunch all week. So other than raising your hand saying, please place me on the jury, the quickest way to be on a jury is to remain quiet. And I tell you that because the state and the defense are each going to have 45 minutes to talk to you. They don't have a chance to go to your house, spend time with you to figure out what your thoughts and ideas are and everything. So please give them your undivided attention and answer all of their questions. Does anyone need a break before I turn it over to the state? All right, so everyone, this is what we're going to do. We are going to come back at 11:50. Look to your left, look to your right. You're responsible for that person. And what I'm going to need you to do is when I excuse you, and I'm just excusing you to take their short break, you need to not come back in the courtroom. You're going to line up outside in the same order that the deputy lined you up. Can everyone do that? All right, so leave your numbers on the bench. Everyone, please rise for the jurors.
All right, State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
Okay, so we're 6 minutes away from afternoon, so I'm gonna say good morning, everyone. And reiterate that my name is Megan Galloway and I, along with my partner Jeffrey Wright, represent the state of Texas. And so I have a confession to make to you all. And it's no secret that there's a lot of construction going on downtown. And so this morning, when I was on my way to work, I came up to a lane where one lane was closed and it was being forced to merge. And so I was in a great hurry this morning. And so usually I would, let the person that needed to merge, but I was like, I'm sorry, buddy, I can't let you merge this morning. And so I confess that to you all here today because you're sitting there saying, hey, that is that jerk that did not let me merge this morning. Speak now or forever hold your peace, okay? And so Judge Boyd let you all in on the greatest secret in the courthouse. And that is that people that do not speak up in jury selection are likely the ones that are going to end up on our jury panel. And so I know you probably feel like this, please don't call on me. However, if you do not speak up, there is a very big likelihood that you're going to end up with this impaneled. And look at how happy those people look to be on the jury. But I want to talk to you about the purpose of jury selection, right? And what is that? It's to talk about the law that would apply in this case and get to know you all of our panel members, because both the state and the defense are looking for 12 fair and impartial jurors that are right for this case. So I want to ask you all, does anyone know who this is? Willie Nelson. Okay. And juror number 7, can you tell me what Willie Nelson loves? Weed, right? And so I have something in my jury selection that I call the Willie rule, right? Because Willie Nelson fundamentally disagrees with any laws governing marijuana. And so if this was a possession of marijuana case, it wouldn't be in this court, right? It would likely be in a misdemeanor court. However, does anyone think that he would be the right to juror for that case?
No.
Probably not, right? And so what the Willie rule is 1, do you understand the law that's going to apply in this case? 2, do you disagree with the laws? And 3, ultimately, can you follow the laws that you're going to receive from the court if you are on the jury panel? Does everyone understand that? Yes. Okay. And I also have another rule in my jury selection, and it's called the no waffling rule. Okay, so I pick juries quite a lot in this court, and I come across people sometimes that I ask them a question and they're like, I refer to them as like the little engine that could, because they say, well, I think I can. And I'm sorry to inform you that that's not good enough. So I want you to really listen to the questions that I'm asking and then identify yes or no with what, fits your beliefs. Okay, does everyone understand that?
Yeah.
Okay. Now, the judge told you all that the burden in this case that rests upon the state is beyond a reasonable doubt, right? And so she let you know that there's no definition for that. So I can't tell you what it means, but I can tell you what it does not mean, okay? So it is not beyond all doubt. It's not beyond all unreasonable doubt. It's not beyond a shadow of a doubt. It doesn't even really mean that you're 100% sure, because does anybody know what you would be called if you were 100% sure what happened on the night in question? Juror number 14? Oh, okay, juror number 13, did you have me on top of that? Okay, defendant or witness, that's a fair answer. And so I want to just remind you all that beyond a reasonable doubt, it goes to the elements of the offense. So we're going to talk about the elements in a little bit, okay? So juror number 20, juror number 21. Do you own pets? Yes. Okay. Can you tell me what went on in this photo?
The dog got into the garbage.
Okay. And how many people in here would say that's just an assumption based on the photos? Okay. Correct. Okay. It's a good assumption though, but let's talk about that, right? So how does the state prove a case? Well, let's look at this through the hypothetical of the state of Texas versus Hubbard's. Okay, how would the state be able to prove their case? Testimony is evidence, so you may hear from testimony from the owner, right? And the owner could come and testify, hey, I'm the owner of the house. I was in the house at the time. I was sitting on the couch and I heard the dog in the kitchen. And when I looked over, he was standing over by the trash. There could be testimony from a neighbor that was looking in from outside saying the same thing. And then there could also be additional evidence in the form of photos or anything else, right? So knowing that beyond a reasonable doubt is a standard, is there anyone here that would hold the state to a higher burden and say, hey, I need to be 100, I'm going to require 100% proof? If you would hold the state to a higher standard, please raise your card. Yeah. Okay, so you understand the burden, juror number 17, beyond a reasonable doubt, but you're saying that you think the state should be held to a higher burden. Absolutely. Okay. Does anybody else feel like juror number 17?
I do.
Juror number 2, juror number 18, 46, and 63. All right. Now I have this question I want everyone to answer, and it's, what is your opinion of the criminal justice system? So you have 4 choices here. 1, you think it's terrible, it takes away the rights of citizens. 2, you think it's concerning, it interferes with the rights of citizens. 3, you think it's helpful in that it looks out for citizens. And 4, you think it's beneficial and protects us from the harmful actions of others. So if you most align with choice number 1, please raise your card. How about choice number 2? Juror number 50. Okay, choice number 4. All right. That's 3, 5, 7, 8, 12.
All right, so just a second, everyone, and I'm gonna pause you a little bit. So when all of y'all start talking at one time, court reporter has to take that down. So one at a time. All right, I'll start your time back.
So I'm going to skip over choice number 3, which thinks it's helpful. I'm going to skip to choice number 4, is you think it's beneficial and protects us from the harmful actions of others. So if you must align with that, please raise your card. 3, 7, 8 through 12, 16, 17, 21, 22 through 24, 26 through 29, 34 through 36, 39 through 42, 48, 49, 44, 51, 54, 55, 57, 62 through 64, 65 through 67, 70, 72, 73, and 74. All right, thank you. Now, we're going to talk about the elements for the offense of murder. Okay, and so we're going to talk about there's 2 ways that the state can prove the offense of murder. It's paragraph A or paragraph B. So we're going to talk about paragraph A first. So that's on or about a date here in Bexar County, Texas, the defendant did intentionally or knowingly cause the death of the victim. And then paragraph 2 is the same, on or about a date in Bexar County, Texas, the defendant did cause the death of the victim by committing an act clearly dangerous to human life with the intent to cause serious bodily injury. So serious bodily injury means it's legally defined as a substantial risk of death, serious permanent disfigurement, or protracted loss or impairment of any organ. And so I want to talk to you all about the mental states, right? The legal definition of intentionally is the conscious objective or desire to engage in the conduct or cause the result. So what I think when I think about that is, did you mean to do that? Okay, knowingly is defined as you're aware that your conduct is reasonably certain to cause a result. So what I think when I think about that is, did you know that result could happen and you went ahead and did it anyway? So the law states that regarding mental states, you do not have to be a mind reader. You can infer intent from words, actions, and circumstances. So I want us to go ahead and do that through this exercise. It's a hypothetical involving Marion Crane and Mother. Okay, and so we're going to look at the facts and determine what was Mother's intent. And so the facts, as I'm going to describe them to you, are that Mother obtains a knife, enters Marion's hotel room, enters Marion's bathroom, pulls the shower curtain back, stabs Marion multiple times, causing her death, and then flees the scene. So, juror number 1, can you tell me what you think Mother's desire was based on those facts?
To kill Marion.
Okay, thank you. And juror number 3, can you tell me what was a result that Mother was reasonably certain could have occurred due to those acts?
Death.
Death. Does anybody disagree with jurors number 1 and 3? Okay. Now, regarding this offense, the state does not have to prove a motive to you. Okay, sometimes killings occur and no one knows why, but sometimes there are motives. But the law is that the state does not have to prove the motive to you beyond a reasonable doubt. Does anybody disagree with that? Okay. And so I want to ask you all, can anyone in here think of possible motives for a murder? Juror number 15. Yes, like what would be a reason or a topic that?
I know this probably isn't like the go-to reason, but my father did 21 years of prison for murder.
Okay.
And his was because he was drunk and on drugs.
Okay. Well, we'll talk about that. 20.
Passion.
A crime of passion. Okay. Your number 5.
Revenge.
Revenge. Okay. Can anyone think of some like underlying crimes that you think would maybe lead to a murder? Juror number 6 or 63.
Rape.
Rape. Okay, that's a possible one. What is your number, ma'am? 11. Theft. Theft. Okay.
Say that.
12. Drunk driving. Okay, those are all 39. Okay, we'll talk about that. 48.
Robbery.
Okay. And so here, around here, we have like something that we were called as the big 3, right? And so it's guns, drugs, money, and then sometimes it can be something, you know, involving your partner, which kind of goes to what you were saying, crime of passion, right? But regarding some of those motives, like guns, drugs, money, is there anyone in here that thinks that the state should not prosecute cases where the motive is one of those underlying facts? Like, does the victim still deserve justice even if they were involved in drugs or guns? Raise your card if you feel the state should not prosecute those cases where the motive is one of the ones listed.
I'm sorry, can you repeat the question?
Yes.
Can you repeat the question?
Yes. So I'm asking you all to raise your card if you feel that the state should not prosecute murders where the underlying motive is guns, drugs, or money. No? Okay. So somebody had mentioned self-defense. That is a possible defense that can be raised by the defendant. And so what I want you all to know with self-defense or protection of property is that the defendant is admitting to the killing, but he is just asserting that he was legally justified in doing that. And so what you need to know about the law referring to those defenses is that first, the person that the actor is acting upon has to be engaged in unlawful behavior against the actor, 1. And then the actor would only be justified if, when, and to the degree the actor has a reasonable belief that the force is immediately necessary. So it's very fact dependent. And a reasonable belief is defined as a belief that would be held by an ordinary and prudent person in the same circumstances. And so what I want you all to know about the assertive defenses is it's kind of like this chair that I'm displaying to you, right? You have to meet the 4 elements, okay? If one of those legs fell off that chair and you went to go sit on it, it would all collapse. And that's the same thing with the defense. Now, there is a law that allows a jury to make an inference of guilt from a person fleeing a scene. Does anybody disagree with that law? Juror number 60? Okay. Thank you. And then I just wanted to let you all know that deadly weapon is defined as anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. But now I'm going to talk to you all about the type of evidence that you would expect to see in a case. However, I also kind of want to talk about the evolution of evidence. So juror number 4, can you tell me what you see on the screen before you?
Various ways of recording video and audio.
Okay. Do you know what any of those objects are called?
Got a cassette player, a floppy disk, and a old 8-track.
Okay, thank you. And so I guess those are forms of evidence or mediums of evidence that would have been used kind of way back when, right? Not really relevant today because technology has evolved. Does everybody agree with that? Okay. And so keeping that in mind, like what type of evidence would you all expect to see in this case? Juror number 5. The weapon. Okay, I'm going to get to that in a minute. 6. Video. Okay, and so in talking about the evolution of evidence, let's say that it's been, a couple of decades since the offense occurred. Would you expect to see video in a crime that occurred in like the 80s, 90s, or early 2000s? No. Did everyone hear that question? Would you expect to see video evidence in a crime that occurred in the early 80s, 90s, or 2000s? Juror number 60?
Sometimes there was.
Okay, and right, it's a possibility, but when we're thinking in the context of the evolution of evidence, right, nowadays cameras are everywhere, right? We have Ring doorbells and surveillance videos, all of that. But everybody would agree with me that that was so prevalent in the 80s, 90s, and 2000s. Although it may exist, it wasn't as prevalent as it is today. Is that fair to say? Yeah. Okay. And so knowing that, would anyone, is everyone here able to make a commitment to view the evidence presented in the context of the time period that it was collected? Can everyone do that? Okay. Can you please raise your card if you're unable to do that? Oh, did you raise your card, 14? Okay, thank you. Oh, sorry. All right. And so the big point that I'm trying to make to you all is, right, testimony is evidence. And we kind of talked about that, right, in the hypothetical with state versus puppers. But in any given court, right, the brunt of the evidence that you would receive is from witnesses taking that witness stand and testifying to their personal observations, okay? And so juror number 5 brought up a good point that because this is a murder, he would want to see the murder weapon. And so my question to you all is, why would the state be unable to bring you this evidence? Does anyone have any idea? Juror number 33.
The weapon was thrown away, destroyed.
It was thrown away or destroyed. And when you say that, by who?
By anybody.
Okay. Somebody else had raised, well, I'm going to jump over here. Juror number 16, do you have any idea why the state would be unable to bring that evidence? Not being able to find it? Okay. Juror number 20.
Improper chain of custody.
Improper chain of custody? Okay. What is your number, ma'am? 18. Do you have an answer to this question? That's possible, right? She said inadmissible. Juror number 19. Do you have an answer for this?
Nothing beyond what's been said, just that if the perpetrator may have disposed of it, or maybe they were working with someone else who might have disposed of it on their behalf.
All right. And so that was my next question that I was going to follow up with. If someone does not want to be caught for committing a crime, what are they going to do? And does everybody have the answer that juror number 19 just said? Right? It's a strong possibility that they destroyed the weapon. And so this is a concept that we've known, it's in media, right? Luca Brasi sleeps with fishes for being a snitch. And so is there anyone in here that would require the state to produce the weapon as evidence? Please raise your card. Juror number 5?
No.
No. Juror number 46. Juror number 22. Juror number 39. I'm gonna ask you to raise your card if you would require the state to bring that as evidence, and please keep it raised until I call your number, okay? Even if I called it already, please raise it again. All right. Jurors number 2, 3, 22, 23, 39, 46, and 75. And 58. All right. And I'm gonna ask you all to raise your cards again because I have a follow-up question for you all. Okay. So even if you heard testimony from multiple witnesses that say, hey, I observed X person with a firearm, and you believed that testimony beyond a reasonable doubt, would you still be unable to make a finding of guilt without that weapon? Okay, so juror number 2, you would still be unable to? Can you say yes for the record?
Yes.
Juror number
Yes.
3. Who is next? Juror number 22. Would you still be unable to make a finding of guilt?
Can you repeat your question, please?
Yes. If there were multiple witnesses that came to testify that they observed an individual with the weapon, but it was never recovered, and you believed that witness's testimony beyond a reasonable doubt, would you still be unable to render a finding of guilt if the weapon was not recovered? Okay, so you're saying that you can listen to the testimony and make a finding of guilt based on that. Okay, 23.
I would say that also.
You would
I'm
be
sorry, I
unable-
can't hear you. You need to stand, sir.
No, to the way you originally presented it would be, yes, I could convict if I didn't. have the weapon.
Okay, so you can just listen to the testimony, and if you believe it, you can make a finding of guilt
Yes.
based on that. Okay. 39? Yes. You can listen to the testimony. Okay. 46? You can listen to the testimony. 58? Okay. You can listen to the testimony. All right, thank you. 75. Would you be able to listen to the testimony, or would you require the weapon? Testimony. All right, thank you. Now in a jury trial, right, you may hear from a multitude of witnesses. It could be police officers, civilians. You may even hear from the defendant, although the judge, that is the law, the defendant does not have to testify, and any witnesses that the defense may bring. And so regarding witnesses, right, and this is kind of what we were just talking about, you all as a jury members are the exclusive judges of the facts proven, the credibility of the witnesses, and the weight to be given to their testimony. Okay, and so I have a question for you all, and that is, what does a victim of crime look like in Bexar County, Texas? Juror number, what is your number?
8.
8. Do you have an answer to that?
No,
No? 9?
like a victim as in just like any sort of crime?
Yeah.
Victim, and it could be that, could be somebody that hurt me.
Okay, and so my question is kind of rhetorical, right? Because a person that is a victim could look like anybody in this room, right? And so what I'm really getting at is, how are you able to judge someone's credibility, right? There are multiple ways. You look at when they made their statement. Has their story changed? Does their story match up with other evidence that was presented? And then ultimately, do they have a bias or an incentive to testify or lie? And so would anyone hold it against a victim or a witness if you just don't like the way that they look? Or they have tattoos, or they grew up in a part of town that you don't agree with? If you feel that way, please raise your card. Okay, so is everyone here making a commitment that you will listen to the testimony of each witness before you make an assessment on their credibility based on looks? Can everyone do that?
Yes.
Did anybody know who this is? Mulan, right. And so the reason that I put this slide up is because in this part of the movie, she's singing a song called Reflection. And My point in that is that in any given criminal trial, the defendant may resemble somebody that you know or love, a cousin, a brother, a friend. But ultimately, when you receive the law from the court, you are going to be instructed that you cannot let sympathy play any part in your deliberations. And so my question to you all is, if you heard the testimony of witnesses and you believed that the elements were proven beyond a reasonable doubt, is there anybody in here that would not be able to set aside any sympathy that they feel for the defendant? If you would be unable to set aside sympathy, please raise your card. Juror number 15. Thank you. Anybody else? Okay. And so this next question that I have is just asking your opinion of law enforcement in Bexar County, Texas. So 1 means that you do not like law enforcement at all. 2 means that you're wary of them. 3 means you're okay with them. And 4 means that you believe that they do an important job in our community. So if you most align with choice number 1, please raise your card. You don't like police officers at all. What about choice number 2? You're wary of police officers. That's 1, 7, 15, 19, 30, 32, 46, 50, 58, 63, 69, 71, 72, and 74. Now, out of you all that just raised your cards, can you please raise them again? Or I apologize. But I do have a follow-up question for you. So out of the people that have their cards raised, that opinion that you have of aligning choice with choice number 2 the most, keep your card raised if that's based on an experience that you personally experienced or somebody that you know or love or a friend. Okay. So juror number 15. That personal experience, would you be able to set it aside and judge the credibility of the witness that takes a stand? Or was that experience so negative that you would be unable to set it aside? I don't think I can set it aside. Okay, so you can't, right? Because this is, forgive me, but you shared something personal with us earlier, right? Yes. Right, and so that's something that has weighed heavily on you, I'd imagine. And so that's something that you're unable to set aside, correct? I'm sorry for that. Juror number 30, would you be able to set that personal experience aside, or would it weigh in your deliberations in this case?
It never left my mind.
Okay, so you cannot set it aside.
I may not.
It's no waffling, guys. Yes or no?
Honesty.
Honesty, right? Because it's never left your mind, right? It's something that's ingrained in you. And so to be fair, you wouldn't be able to set it aside in this case, right?
I can't overlook.
Okay, thank you. Juror number 32, would you be able to set it aside? Probably not. Yes or no? No. Who's next? Juror number 50. You would not be able to set it aside. Juror number 63. Would you be able to set it aside? No. 72. Would you be able to set it aside?
Not be able to set it aside.
Thank you. 74.
No.
Would not be able to. Thank you. All right. Now the judge explained to you all about the phases of trial, right? That first is the defendant guilty or not guilty. And then the second is punishment, right? And in punishment, you can look at a lot more information than what is relevant in the guilt innocence phase of the trial. So the judge did inform you about the range of punishment, right? And so the jury is going to assess punishment in this case if you get there. And so I have a question for the prior jurors. So starting with juror number 2. And the criminal trial that you sat on, was it judge or jury for punishment?
That's a long time. Judge.
Judge, okay. What about juror number 14? Judge or jury for punishment?
Jury.
Okay. Juror number 19, judge or jury for punishment?
It was not guilty, so it was not no punishment.
Thank you. And what about juror number 20, judge or jury for punishment?
Judge.
Thank you. Okay. And so the judge did explain the range of punishment to you, right? That is 5 to 99 years or life in prison with the maximum fine of $10,000. And so the question, which you all answer to Judge Boyd, right, is that you all can keep an open mind and consider the minimum and the maximum punishment in this case. Does everybody still agree with that? Yes. Okay. And that was my next point, right? You all have heard no evidence in this case, and so your answer should be yes. You can consider both. But I want to talk to you all about sentencing, right? And get your feel on what do you all feel is the main purpose for sentencing. So there are 4 choices here. 1 being punishment, right? 2 being deterrence, preventing this from happening again. 3 is making amends, helping the victim's family recover, or 4, rehabilitation. And so if you most align with punishment, please raise your card. 2, 3, 5, did you change your?
Sorry.
Okay, 5, 8, 9, 11, 12, 13, 14, 16, 17, 18, 20, 21, 23, 24, 26, 30, 33, 34, 35, 36, 39, 46, 48, 49, 52, 53, 54, 55, 58, and 73. If you most align with deterrence, please raise your card. That is 10, 15, 19, 27, 28, 29, 38, 40, 50, 57, 61, 62, 63, 66, 67, 69, 70, 71, and 75. Making amends. Who most agrees with that? Please raise your card. Jurors number 6, 22, 25, 37, 72, 25. And rehabilitation, if you most align with that, please raise your card. That is 1, 7, 43, 44, 47, 60, and 64. All right, so now I have a follow-up question. Regarding punishment, what do you all think is the most important factor to be considered when assessing punishment? 1, is it the defendant's age? 2, is it the defendant's criminal history? 3, the seriousness of the offense, or 4, the impact on the victim. So if you most align with choice number 1, the defendant's age, please raise your card. Okay, how about 2, the defendant's criminal history? Okay, that's 15, 17, 24, 26, 27, 30, jumping back to 7, 34, 42, 46, 53, 58, and 59. And if you most align with the seriousness of the crime, please raise your card. Jurors number 1, 4, 5, 6, 8, 10 through 14, 18 through 21, 22, 23, 28, 29, 31 through 33, 35, 36, 37 through 41, 44, 45, 48 through 50, 51, 52, 54, 55, 57, 60, 61 through 63, 66, 67, 69 through 71, and 73 through 75. And who most aligns with the seriousness of the crime that we would be here for? Please raise your card. Is that what
That's what.
And then the impact on the victim. Please raise your card. That's 2, 3, 9, 16, 25, 43, 47, 64, and 70. And the question that, so does anyone here have a family member that was involved with the criminal justice system in some shape or form, and they feel that that person was treated unfairly? Can you please raise your card? If you've already answered, that's fine. So 34, 74, and 75. Okay, and so would you all be able to disregard that experience? What's your number? 34, 75, would you be, and 74 and 75, would you all be able to set that experience aside?
No.
74, no. 75, yes. Okay, thank you. And is anyone here unable to sit in judgment of another due to personal, moral, or religious reasons? If that's you, please raise your card. Okay, no cards. All right, now I'm gonna hop back to this question, and this is one for everyone to answer. A jury's verdict changes behavior in our community. Now, if you strongly agree with that, right, you are feeling that verdicts deter future crime. If you agree, you feel that when the public sees the verdict, they might make different decisions. That was 2. 3 is you disagree. This case is only about the defendant. Or 4, you strongly disagree. You feel that it would have no effect on the community. So if you strongly agree that jury verdicts change behavior and community, please raise your card. That's 5, 22, 23, 26, 27, 28, 29, 30, and 47. If you just agree, right, and that saying when the public sees it, they may make different decisions, please read it. That's 1, 2, 6, 7, 8 through 14, 15, 17, 24, 25, 37, 42, 44, 45, 48, 49, 54, 55, 57, 58, 61, 62, 65 through 67, and 73. Now, if you disagree and feel that it would have no bearing, please raise your card. That is 3, 4, 16, 18 through 21, 31 through 36, 38 through 41, 43, 50, 59, 60, 63, 64, 69 through 71. And then if you strongly disagree, please raise your card. That is 46 and 72. All right, so I have one final question. I'm going to single you out, juror number 6, but you said that you know Mr. Bunk. So would you be able to set aside whatever relationship that you have with him, or are you going to give him an unfair advantage against me because you know him? Sorry?
Set it aside.
You can set it aside? Okay. All right, well, that is all I have for you all. Thank you so much for your time.
All right, defense, are you ready to proceed?
Sure. All right. My turn. Good morning again, or actually good afternoon, it's 12:30. So I'm Lindsay Shaw. Charles and I represent Mr. Mejia. And so, I don't have a PowerPoint. I'm gonna just talk to you a little bit more. I wanna get to know all of y'all because it's important that you understand today is very casual. I know everyone's a little uncomfortable. Probably you don't wanna be here, but at least, hey, you're not at work. Yes, sir.
Turn away from me, I cannot.
Okay, I will I'm just gonna talk directly to you. No. Okay. So pardon my back over here. But what was I saying? It's important that, I know it's kind of weird. We're asking you a lot of sort of personal questions about what you think about really serious things. It's not something that you sit around and talk about, even with close friends or family. What do I think about murder and punishment? I mean, so I get it, but it's important that if you have strong feelings about anything we're talking about today, you let me know. You're probably never going to see any of these people again. I mean, except juror number 6, whatever. You know, so it's a judgment-free zone, because if you don't tell me now, if you don't tell us now, hey, I really am not a good juror for this type of case because whatever, then we know it, we can make sure you're not on our panel and we find someone else that is appropriate, okay? So I guess let's start with, a lot of you or several of you have been on a criminal jury trial. I don't remember seeing anyone who'd been on a grand jury. Am I correct about that? Okay, so a grand jury is something that in Bear County or any county, before a case gets to a courtroom like this one, a felony courtroom, the DA's office, they get the information, they get the police reports, they get everything from the San Antonio Police Department or the Bear County Sheriff's Office, whatever agency has worked up the case, whatever work they've done, talking to witnesses, collecting evidence, everything they do first, they send it to the DA's office. Now, these fine folks, maybe not them, the other prosecutors, they receive the case. They might do some extra work on it, talk to a witness, and then once they think, okay, this is it, I think this is a good case, let's take this to the grand jury. But once they go in that grand jury room, there's no defense attorneys, there's no witnesses. It's pretty much, hey, grand jury members, kind of like you all, but it's grand jury. Here's what the police say happened. The police report says X, Y, Z, and then they vote. Should we indict this case? And that's it. It's pretty simple. So why am I telling you this? Because I want to make sure everyone understands that just because an indictment is brought against somebody, it doesn't mean that you should consider that and whether or not sitting here right now, do I think they're guilty, right? The only thing that has been brought against Mr. Mejia is an indictment. So can everyone agree with me? And juror number 15, I think it's 15. All right, you're a little emotional. Are you doing okay? Okay. Sorry, we're all calling you out today. I'm sorry about that. Okay. Can everyone agree with me and say yes, even though there's been an indictment, okay, brought against Mr. Mejia, I'm not going to consider that. I'm not going to let that weigh on my decision whatsoever. Okay. Does anyone say, you know what? You know, and again, remember what I said, no one's judging you here. But you know what? He's sitting there, an indictment has been brought against him. He's sitting in this chair, so he probably did it. I bet he did it. Does anyone say yes to that? Nobody? All right, quiet bunch. And speaking of that, I want to get something out there in the open. Obviously, you can see Mr. Mejia has some tattoos. Now, those, you know, I don't know, people have a lot of strong feelings about tattoos. Some people love them, some people don't like them. Is there anyone here that feels like because of the way he looks, because he has some obvious visible tattoos on his face, on his hands, that I'm going to hold that against him? Does anyone think if you're going to go and get those tattoos, that's going to affect how I perceive you? Anybody say that? No? Number 29, talk to him.
I know that sometimes tattoos have meaning behind them.
Okay.
They could be gang related, things like that. I don't know personally know a lot about it, but it could have something to do with that. So they're not totally that we can see that it might not affect.
Exactly. I mean, and that's exactly what I'm trying to say. And with that answer, are you able to look at Mr. Mejia and still treat him fairly? You're not judge him for his appearance or his tattoos?
Correct,
Okay.
because I would have to learn what those be the meaning behind if there is to be proven.
Of course. Anybody else? And I'll just say this, Charles and I were in trial last week and we asked this question and several people raised their hands. So I guess we either got a quiet bunch or a very fair bunch. All right. And speaking of being in trial and going back to the indictment, I think it's important to talk about the fact that, you know, yes, there's serious allegations against Mr. Mejia, but there are trials in this courthouse every single day. And every single day someone is found not guilty of a criminal charge. In fact, we had a trial last week and our client was found not guilty. So just because someone is on trial doesn't mean that you are making the wrong decision if after you hear all of the evidence that the state puts on if you decide, you know what, this state, you just didn't do your job. You didn't prove the case beyond a reasonable doubt. Okay, so that's not something that I want any of you to be scared of. And everyone promised me that if you're on our jury, you would stand, you know, even if you're a group of 12 people and 11 say guilty, if you feel like, you know what, I don't think the state proved this case, you would be willing to stand strong and stick to that decision. Everyone can promise me they can do that. Anyone say, no, if there's 11, they all think not, they're guilty, he's guilty, then I must admit that I'll just agree. Does anyone think that they'd probably be that type of juror? All right, nobody? All right. Let's talk a little bit, and the state touched on this, credibility of witnesses. One way that the state presents evidence, and the defense, if we choose to do so, is through testimony of witnesses. Usually it's either officers or it's lay witnesses. Sometimes you'll get some scientists or medical examiners, something like that. But no matter who it is, can someone, juror number, let's see, I don't have my chart here. Just pick a random number. Juror number 8. Can you tell me how do you juror someone's credibility? What's an example? How do you know if someone's telling you the truth? You don't know? Number 9, help them out.
I mean, it depends. I mean, if they're an expert in their field, that provides some credibility. I mean, possible to know for sure, but like you said, if you have somebody that's a witness stand that knows what they're talking about, and they can prove that.
Okay. Number 10, how do I know someone's telling the truth?
Hopefully the sound facts.
Okay.
If something's linked.
Number 11, what about you?
I can't hear them. As long as there's no contradictory evidence.
Okay, that's a good one. Contradictory evidence. What do you mean by that?
That's different than what we saying.
Okay, so sometimes stories change, right? Why do you think that is? Maybe because they're not telling the truth, right? Let me ask you this. When would you expect someone's story to be the most accurate after a crime, whether they're a witness or a victim of it? Juror number 12, yes, ma'am. Right after, right? And why is that? Memory. As days pass, time passes, they tend to forget things, right? They might remember something differently. It's possible that when you're involved in a traumatic event, that you black parts of it out, right? Or is it also possible on the other end of that, that when things happen, it's just so traumatic, it's so sudden, whatever, that maybe, you know, your memory, you'll never remember it correctly versus when it was really happening. I guess I'm kind of saying the same thing, but going back to your point, right? Your memory is always best right at the beginning. And so why do you think, well, let me rephrase that. Kind of fell into my next thought here. Why do you think that, well, I think, let me talk about it. Now, we talked a little bit, the state talked about bias and fairness, and we've gotten a lot of cards raised. But this is a tricky question to ask, and it's a hard question to answer. But I just want to make sure that no one else feels like, hey, you know what, I didn't raise my hand, but you know, I've heard the state and I've heard you talk a little bit. I really don't think that I would be a fair juror on this case. Because remember, what we want is a fair jury. What the state wants is a fair jury. Everyone wants the best 12 of you to be on our panel. So does anyone here, maybe that you didn't raise your hand before, but you feel like and maybe you need to tell me or the court in private. But if you feel like, you know what, I cannot be on this jury for one reason or another, and I didn't raise my hand earlier, can let me know. Any cards? Number 28, is it something you can talk about now, or is it something you would need to say in 5 minutes?
Because my English not that good, I have a hard time understanding what the
Okay, so just because of your language barrier. Okay, anybody else? Number 20, yes, sir. I'm sorry?
I would have to discuss that, please.
Okay, so it's something that you would need to approach the judge on. Okay. Okay. 69, yes, ma'am.
I don't know if this applies, but you sometimes see in these procedural dramas where you have the expert witness and try, I tend to like, if an expert witness, if that is their business and their testimony is required, I tend to kind of be opposite.
Okay, all right. And why is that?
Well, because it sounds like their opinion is swing one way or another, but it's affected by money and not.
Okay, and so then, would you, with that in mind, are you still able to be a fair juror on this case? If we, let's say hypothetically, the defense for Mr. Mejia, we were to call a witness that was an expert that we had hired. Do you think you could set that aside, that fact, knowing that he was a hired witness for us and listen to his testimony and still judge his credibility?
If my answer to that is, how would we know the difference between a witness that is for hire and somebody that is just, is it public?
Oh, sure.
Yeah.
Well, most likely, if we didn't get it out in front of you, then the state would ask about that, right? Because that's something the state might want you to consider. But, nevertheless, this kind of goes back to what I was talking about with the credibility. We would ask you, in order to be a fair juror, can you, even knowing, I'm not saying that we have a hired witness, but if you found out we did, can you still set that aside and say, you know what, I know he's hired, but I can tell he's a qualified individual, or she, and I believe I'm going to listen to what they're saying, and it sounds, if you believe what they're saying, then you're not going to hold it against them that they're a hired witness.
I believe what they're saying, I would not hold.
Okay. Anybody else want to add on, comment, question? No? Did you hear any of that? No? Okay. I guess the question was, let me ask you over here. If you found out that the defense, for example, had hired a witness, would you, knowing that, would you let that affect your credibility and how you were going to perceive them? Okay. Can you think of a reason why we might hire a witness, or why the state might?
Be an expert in the field of, I don't know, forensic or something like that, evidence or something, they have their take on it versus state.
And everyone understands that oftentimes a lot of scientific evidence or scientific experts they do come for the state and they are not paid. Okay, so it kind of goes back and forth, right? And so if you promise to treat them fairly, you would promise to treat our witnesses the same, correctly? Correct? And so, as we get to the end here, the state talked a little bit about the range of punishment. But I want to make sure, y'all were quiet about that too. The range of punishment on this type of case on a murder is rather large, right? A minimum of 5 years in prison and a maximum of life in prison. And anyone think of give me an example of why we have such a large range of punishment. Juror number, let me call on sometimes there. How about juror number 25? Why would there be such a large range of punishment?
Can you stand, please?
Oh, sorry. Because the severity of the crime would be very minimal to the highest.
Okay. How about juror number, let's see, I'm gonna pick on number 27. Why is there a range of punishment?
My opinion, I think for deterrence sake.
I'm sorry?
Deterrence to
Deter.
ensure that,
Okay.
going forward, someone else thinks twice before taking such.
Okay. All right. Anybody else have thoughts? 54, yes, sir.
Consequences.
Intent and consequences. What do you mean by that?
Go with working forward.
Sorry.
Oh,
So I'm going to
still
pause.
stand, I'm
So
sorry.
everyone, you have to stand when you're answering so that the court reporter can hear. And everyone, please keep your voice up. All right, you may proceed.
Say that it's being a sport or some offense, you know, if it was just for fun, I think
Sure.
that would be cause for severe punishment. If it was for some offense, lower punishment.
Okay, absolutely. Then number 34, yes, sir.
Criminal history.
Okay, thank you. I was gonna suggest something like that. So those are all things we consider, maybe why, the intent of why they did it, or their criminal history, or, you know, all of those things. Yeah, and so maybe if someone is lacking in that area, or if the state is able to prove intent and it's gruesome, you know, those are all the reasons why we have that range, okay? So without knowing the facts of the case, can anyone here say, look, just because it's a murder charge for what the charge is, if Mr. Mejia was found guilty, I could never ever and wouldn't consider the lower end range of punishment. I would never consider 5 years. And this, remember, this is, you don't know the facts of the case. You don't know anything. But does anyone say, if he were found guilty, I could not consider the full range, meaning I would never consider the minimum? Number 20, yes, sir.
If I understand correctly, the minimum being, of course, like the 5 years versus the full.
So you could not, if,
Okay, so let me pause for a second. Everyone, I'm gonna need you to please stop mumbling because the court reporter cannot hear. And I can't hear. And if you're not sitting in the positions that the numbers I called out, if you can stand, I'm gonna need you to stand so the court reporter can hear. All right, you may proceed.
okay, so you were saying juror number 20, if you were to be on this jury and you were to assess punishment, really, and that's only if we get to that part of that phase of trial. But if you know now, even having heard no facts, if there was a guilty verdict, you could not. And this is a tricky question, I understand, because you think, okay, murder, would I give the minimum? But I want to make sure, as I represent Mr. Mejia, Charles and I, my job is to find fair jurors. And so if I know you can't be fair by considering the range of punishment, then, you know, I want you to tell me. Okay, so does anyone say, like you do? You're saying even if, having not heard the evidence, if there was a guilty verdict, you could not consider the full range of punishment?
That is correct.
Anybody agree with juror number 20? 18, you agree? Tell me why.
I would agree, just because I feel like if there were guilty verdicts, it's a very serious crime. I'm not sure if 5 years would be.
Okay, so you could not follow the law. And that's okay. That's just what I want to know. Anybody else? I think I saw a card in here. No? How about over here? Nobody? I've had my back to you guys. Anybody else? All right. Number 3?
Yeah,
Okay, talk to me, sir.
just because of the severity of the crime.
So you agree with them?
Yeah, same here.
Number 2, you agree?
Yes.
So not heard any facts, not knowing anything about the case. If there was a guilty verdict, you could not follow the law, meaning consider the full range of punishment.
If it involved murder, no.
Okay, so that's juror number 2 and 3. Anybody else? Number 8, you feel the same? Not heard any evidence, you could not follow the law as to range of punishment. Okay, that was number 8. Anybody else? Yes, sir.
So are there established guidelines between that range of 5 years? There established guidelines to say what the state of 5, 10, and 20.
There is not. Now, if we were in a federal court, that would be a little different. There are there's more guidelines there, but here in a state court, there are no guidelines. The guideline is 5 to 99 or life in prison. Okay. Anybody else agree with 20 and 18? Number 27. Yes, sir.
I think I agree with them on the basis that if, since if it's murder, having even heard it, that, will be skewed, you know, to give the minimum sentence.
Okay. You would be scared, but
Skewed, as in I wouldn't want to
Oh,
go in
okay.
that direction.
okay.
Okay, let me pause you for a moment. So everyone, I'm going to stress this to you, and I'm trying to stress it. The court reporter has to take down everything that everyone says. if you are not in the jury box, she can't hear you if you don't stand. On this first row, you don't have to stand, she can hear you, but everyone else, the acoustics in this courtroom are not good at all. So I know you all are talking and you think we can hear, but we can't. And how I can tell that she's not able to hear you all because she's doing everything in real time and I can see what she's typing. And when she starts moving slower, that tells me that, like me, she's not able to hear. So if you're not on those 3 rows, I'm going to need you to stand when you're answering your questions so she can hear. All right? All right, you may continue.
Thank you, Judge. All right, I think, anything else you want to add?
No.
Okay, thank you, sir. Anybody else? Number 58, yes, sir.
I just have a question in regards to sentencing. If it is judge versus jury based, how do you know, like, beforehand, like, if we would be handing out the sentencing or if it was the judge?
Sure, so that is something that Mr. Mejia and Charles and I discussed before trial. The law requires that before we start a trial, we make that selection known to the court and to the state. Okay. Number 72, yes, sir.
I would not consider the minimum sentence if it's a murder case.
Okay, so even having heard no evidence, and I just asked because I got to make sure we get it right for the record. Okay, you would not be able to consider the range. Okay. Number 33. Yes, sir.
Yes, ma'am, I would say the same as him. It's, I'm being honest here. It'd be hard just to do the minimum.
Okay. So you could not follow the law. Okay.
Nothing, no.
Number 49.
I agree, I would have a difficult time giving them as well.
Okay. Anybody else? I saw a quick number. No? All right, well, I appreciate y'all's time. Charles is going to say a few things, but thank you very much.
Good afternoon. Man, I'm telling y'all, y'all gonna have like 100 jurors at this rate. Here's how this works, just so you'll know. When we're finished, they go to their room, we go to our room, we both cross off 10 people for any reason we don't like. Anything. We can say, man, I cannot stand ladies in glasses. Anyone, you're out. Whatever. We cross 10 off, they cross 10 off. So we're not picking who we get, picking who we don't get. The best way to get on is to stay quiet and not answer anything. Now I want to talk to 69 back here. I think it's 69. I like what you said. And when you said that, I thought about, that kind of would apply also to cops. Because I mean, are cops paid to be here? No, but they're supposed to come and they know what they're supposed to say because they work with the state. So just like an expert, I'm having trouble seeing you. I mean, just okay. Just like an expert, can be paid and they're expected to say certain things. That's kind of the way I feel about cops. I think they're expected to say certain things. For example, if a detective has worked on a case and done his work shoddily, kind of rushed to judgment, if you will, and says, hey, we did our work and this guy is the guy that did it. I feel like every other cop is going to come in here and say, hey, we did our work and that's the guy. Because that's what I'm supposed to say because we're working with them. And my concern is sometimes, believe it or not, witnesses get it wrong, right? 18, you're nodding yes. Is that right? Why would a witness come in here and say something that wasn't true?
Memory serves incorrectly.
Memory served incorrectly. Three.
Emotional.
Sorry?
Emotional.
Emotional. 12. Payback. So in other words, I was there when this thing happened, and my partner Lindsay did it. But I like her. She's my partner. I'm not, so when the cops ask me who did it, I'm gonna go, she did it. I mean, that's a good that would be a reason, right? Yes, ma'am, 29. Perspective.
I might have been looking through the back or a certain direction.
Right.
And so I might see one thing, but somebody else on that other side that something else.
Sure.
So it's just the way different people.
We saw it we're looking at it from different perspectives.
Yeah, different.
And I think that all of y'all agreed, and Megan brought this up. One of the things when you judge credibility, do the stories match? She said, have they changed Or do they not match other witnesses? Now, some of that 29, I think, can be perspective.
Yeah.
But if two witnesses, let's just say whatever happens, and Lindsay and I are the ones that did it. And Jose is a witness to it, and he tells the jury, I saw Lindsay and Charles run out and jump in a Suburban. And Megan was a witness, and she says, I saw Charles run out by himself and get in a Volkswagen. That's more, would you agree with me, than just a different perspective? Those are stories that don't match. And who agrees with me, when you have something like that, you need to take pause and think, man, that needs to be fixed. Somebody, either both of you are wrong or somebody's not telling the truth, right? And who would be surprised to know that that happens in criminal trials all the time? Anybody not surprised by that? 63. You think that doesn't happen?
No, I mean, I think that happens
all the time.
Yeah. Surprise.
Now, another thing I want to talk about, just from my personal perspective, is, I've been doing this a long time. I was them before them. The judge and I worked together longer than I'll say, just because she's only 21. I like the judge. She's a very dear friend of mine. I like the state. The way the whole criminal thing in San Antonio, the way it works is Lindsay and I come to court every day. And we go from court to court to court. These people sit here all day. This is their home. She's the boss of the 187th District Court. Everything goes through her. So I'm in here a lot. We have a lot of cases other than this one. The reason I say this is something I'm always worried about, because I like to think that I'm a friendly person. And I like to think that I don't want to say, I like to think, I know I love my job. I love coming over here every day. I love helping people that are charged with things they didn't do, or that need help because they did something, but they're being treated unfairly. I love that. So you may see me in the course of the trial lean over and tell Megan something and laugh, or smile when I talk to Jeffrey. Don't make the mistake and think, hey, Bunk's just doing his job. He doesn't really care. I care, but I'm not going to stop being their friends. I'm not going to stop being the judge's friend. So don't, I'm always told, Charles, man, you were talking to the state and you look like you were laughing about it. It has nothing to do with this. It's something else. So don't think if you see me talking to them or talking to the judge that I've given up and I'm mailing it in for Jose, because I'm not. I'm friends with them, but I can tell you on this case, we disagree 100%. We have a different perspective, if you will. That makes sense? Okay. Now, a lot of people said they can't consider the minimum, and I get that. It's a murder. Somebody died. Somebody killed somebody. But I want to go back to what the judge said about the husband and the wife. She said that's also murder. So murder can be a lots of things. And that's, are there guidelines? No, because murder can be so many things. So those of you who said you can't consider the minimum, remember the kind of murder the judge described where it's a mercy killing. Maybe in that case, those of you said, you know what, I can't give a murderer 5, maybe reflect and think, well, if those were the facts, maybe I could consider the minimum. Now, would every murder deserve the minimum? Of course not. Of course not. I'm not sitting here telling you, hey, I don't care what they say somebody did, you got to give them 5. I'm not retarded. I get it. You can't do that for everybody, but there are particular cases where that might apply. The judge made a perfect example of one of those types of cases. So those of you who said, hey, I can't consider the minimum no matter in a murder case, no matter what, does reflecting on what the judge said in that type of case maybe change your opinion? Anybody? 3, yes, it does. 27, yes, it does. Anybody else? 49, yes, it does. And 49, you said that you didn't say, actually, I can't consider it. You said it would be difficult. And I think that's the right answer. Because the question isn't, hey, is it going to be easy for you? Of course it's not. It's not supposed to be easy. The question is, can you consider it? Would it be difficult? That's fine. You are absolutely 100% accurate in saying, I can do it, but it would be difficult. That's 100% fine.
What's not fine is someone says, you know what, I don't care what happens, I'm not gonna do it. I don't care what kind of case it is, I will not consider it no matter what. Everybody understand the difference in that? 20, are you 20?
Yes, sir.
Now you had raised your hand and said you couldn't consider the difference, you couldn't consider the minimum.
I want to say that, if we're arriving at a course guilty conviction, then I believe we've seen evidence, so that's why it's compounding.
You've seen that, I'm just saying, there's different types of murder. Right, there's the mercy killing, like he said, and then there's what happened in Uvalde. Right, they're both murders. Do those people deserve the same punishment? Hell no. That's why there's this range that this gentleman asked at 16. Is it 16? That's why he asked, is there a range? There's a range for those reasons. You don't get guidelines, but there's a range because it can be lots of different things. And it wouldn't be fair to say, hey, if you kill somebody, you get X. Right, because every murder is not the same. And then also on top of that, you get to consider perhaps, has somebody raised their hands for criminal history? Have they been in trouble before? You know, if you do find somebody guilty and you find out, man, what he did was bad, but this is the first time he's ever been arrested. That's one scenario versus what he did was bad and this is 13th murder conviction. That's a huge difference, right? Those two people should not be treated the same. 16, that's why there's a range. That makes sense? All right. Now, Lindsay started with it, and I'm going to end with it, fair. That's the only word that you really need to focus on, is can you be fair? Can you listen to the witnesses when their stories don't match, or they're changing their stories? Can you question that and use your common sense to go, man, hold on, something's wrong? Can you be fair to everyone? Can you be fair to this gentleman who's sitting here? Most important week of his life. He's scared to death that because these people in the blue suits say it happened, then y'all are all going to say, well, hell, it must have happened. You have to be fair. You have to listen to the evidence. If a cop comes and says something that you don't agree with, then don't agree with it. That's fine. 69, like you said, if an expert comes and you think, man, you're paid so much money, I'm questioning your credibility. That's the jury's role. That's what you're supposed to do, right? Now, I would say I don't know, did anybody watch The Lincoln Lawyer? Am I the only guy that watches that? Okay. There was a witness on an episode I watched last night. And the witness, she had a degree from Harvard and a PhD from MIT and then something else, and she was so smart. And so she was testifying, and it was, what she had to say was obviously intelligent, based on intelligence and science, but she was an expert. So there may be experts you hear that you think, you know what, I know they paid you, but what you say makes sense. What you say matches the facts. So, I'm going to discount the fact that they pay you because I'm going to tell you right now, as a defense lawyer for the last 20 years, almost 20 years, I can't call up, who's an expert, who considers himself an expert in their field. Everybody raise your hands. Come on, this is a little bit. Everybody. Okay, this gentleman with the beard back here, 38? What do you do?
I'm an intelligence analyst for the Department of Defense.
Okay, you're an expert in your field. If the defense called you and said, hey man, I need a week of your time, will you review 7,000 pages of documents, 100 videos, and then come fly over here to San Antonio and testify about it? Do you think he's going to do it for free? Of course not. I'd have to pay you. That makes it 69. You get that? Of course. I just want jurors that can use their common sense and can be fair. Everybody promised me they can do that. Yeah, that's all I got. Thank you very much.
All right, thank you. Can I see state and defense, please?
This is what I'm going to do. You are not excused for the day.
but I'm gonna allow you to go and have your lunch. And I am gonna have y'all back here at 2:15. So this is what I need you to do. Look to your left. Look to your right. You're responsible for that person and you all need to be lined up outside of that order. So I'm gonna need y'all to one, and all your personal items with you. But leave the numbered cards behind. And so we will see y'all back at 2:15 and you'll be kind of checking out the order.
There's more places other than the cafeteria downstairs.
Right.